May I please, your Lordship, I pray for listing a matter for withdrawal, promotional Lordship.
With the consent of the addressee, Lordship, I beg to mention item number 12 and 13. Lordship, here I am for the respondent insurance company. The dealing counsel, Ms. R.D. Mazumdar, is conducting a mediation program. So only for this week, I am asking for an adjournment, Lordship.
Okay. You have informed the other side.
Yes, Lordship.
Your good name, please.
SP Sharma.
Mr. S.P. Sharma, Learned Counsel. Appealing for respondent number 1 has submitted that conducting counsel, Ms. R.D. Mazumdar, is not in a position to conduct the hearing today in view of her involvement in a mediation program. He has thus sought for listing of the case after a week. It is submitted that consent has been taken from the learned counsel for the appellant and other respondents to make the prayer. In view of the grounds cited for adjournment, the request is accepted. Release the case after a week on date to be fixed by the release the appeal. Same 13.
Lordship, date.
Next week, Lordship, it may be 24.
No. Registry will fix the date.
Lordship, prayer for listing on writ petition, Lordship. The matter was last listed on 1/6/2026.
Please give it to the court master.
Highly applied, Lordship.
May please, Your Lordship, I beg to mention item number 8. Your Lordship, due to some medical emergency, the senior counsel is not present today. Your Lordship, kindly the matter may be taken up on Tuesday due to some emergency actually.
Miss
B. Talukdar.
B. Talukdar, Learned Counsel, appearing for Mr. S. Das.
Yes, Your Lordship.
Learned Counsel for the petition has submitted that Mr. Das is what? Medical emergency?
Yes, Your Lordship.
Okay. Mr. Das has some medical emergency today, and therefore the matter will be listed on another date. You have informed?
Yes, Your Lordship.
Okay, it is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer. Raise the case on side for Thursday.
8 September 0809.
No,
So
Your Lordship,
not possible.
18 September 18.
Any interim order?
Sound ready, sir?
Silo, interim order, side.
Supplementary list for withdrawal. Item 17.
On behalf of Mr. S.
Mr. D. Gogoi, Learned Counsel, appearing for the petitioner, has submitted that he has instruction from the petitioners not to place this writ petition. Mr. A. PROCEED, Learned Standing Counsel, Revenue Department, for the number 1, Mr. N. Goswami, 2 and 3. AIDC are present. In the above submission made by Mr. Google, a writ petition is dismissed that has not placed interim order, passed as a standstill call.
Daily lists for motion. Item 1. Which item 19 of the supplementary list?
You looked at the requisition matter as to whether on the last occasion, government was to take instruction whether the appeal is pending or not.
Malas, we have filed one IA for implementing NRL.
Let us have this instruction. More order reduction. That was a more order. Yes, appeal is pending. Let them decide.
Let them decide until that appeal is decided. They should not possess me.
We have already passed an order in similar situation. No, no, more issue. Here it is their case. They have filed an appeal,
My lord.
whether it is a case under section 3(1) or not. That is limited to that final authority is the government as per section 3(3). The decision of the government is final. Who are you to interfere?
My lord, the property has been requisite for us.
Requisition is different concept.
My lord.
If you go into that, maybe you will be in trouble.
My lord.
Is it covered under section 3(1)?
My lord,
Then it will be, court will make an observation before government deciding it. Show us from 3(1) that you are a necessary party.
my lord, in the past cases also, my lord.
This is an independent 3(1)
Malad.
order,
My lord.
right?
My lord.
Take the book, show us which purpose is going to be served. Are you fine? Are you an organization for homeless and landless people?
No, my lord.
Huh?
No, my lord.
Or any water embankment, water resources, river embankment?
No.
Huh?
No, that is correct, my lord.
Then if you go into that aspect, then you may not be a necessary party, primacy. Because it is between the petitioner and their property is going to be requisitioned or already requisitioned, is it not?
My lord, that's correct, but it is when
And where is the scope for you under section 3(1) and 3(3)?
that is correct, my lord.
Their simple prayer is that let my appeal be decided.
My lord.
Government may decide it within 1 day or within 1 week, or they may take 2 years. There is nothing. Yes, Mr. Prohibitions. Mr. Sarabhati, we have already disposed of one petition, that order to be passed under section, the order passed under section 4(1) will abide by the decision taken by the government in the appeal. Until that time, status quo.
Your lordship is referring to order dated 22/6/26. WPC number 3204.
Yes, last part. Last part, some modification.
Yes.
With
And
some
the
modification.
facts your lordship has already recorded in the order of 11(8). That last paragraph only will be.
You want insistence, you were seeking this.
No, my lord, what I want to submit, my lord, there was a similar situation wherein NRM has made a party. A similar situation, my lord.
So as you are a necessary party, establish yourself to be implemented.
My lord, this property has been taken for NRL to build a industrial hub, my lord. So we,
Make your submission from section 3(1).
3(1) is all, that is correct.
Then make submission on the basis of 3(1), like your requisition. You are in interloper.
My lord.
এখন requisition আশা এই সেউজীয়াখনৰ পৰা দিব ভলিউম 2।
Only one thing, my lord, what we wanted is that we may be heard before an order is passed. That is the only liberty that we wanted.
Where?
But that was the only liberty.
Which court? This court or appellate court?
This court, my lord.
I'm hearing you. Make your submission on the basis of 3(1). Which purpose? Which one? Maintaining supplies?
No, my lord, that is
services essential to the life of the community, for providing proper facilities for accommodation, transport, communication, irrigation, anti-erosion. Numaligarh refinery is involved in anti-erosion measures?
No, madam.
No.
No, madam.
Embankment,
No, madam.
drainage, land individually to groups of landless person, flood affected person, displaced person. You are not a cooperative society. You are not a company incorporated under Companies Act for benefit of rehabilitation of landless, flood affected and displaced person. To provide land for the purpose of construction of border fencing. Bottom I to lock. Hard. I. Mr. A.K. Sahewal. Learned counsel for the applicant. Mr. D. Shanapati. Learned counsel for the opposite party number 1. Mr. Aforesaid. Learned standing counsel. Revenue and Disaster Management Department for the respondent opposite party number 2, 3, 4. And Mr. N. Goswami, learned junior government advocate Assam for the opposite party number 5, 6, and 7. Close to para. The instant interlocutory application is filed by the applicant seeking its implement as party respondent number 7 in the accompanying writ petition, WPC number 4268, 2026. Post of para. The accompanying writ petition, WPC number is preferred by the opposite party number 1 as the writ petition to assail an action on the part of the state, on the part of the opposite party number 5. In passing, an order under section order dated 6/9. What is the date?
6/6/6.
Page 35.
43.
43. No. First
Which
3-1, 3-1.
Section 3-1.
Ah.
6/5. Page 34.
Passing an order under section 3-1 of the Assam Land within bracket Requisition and Acquisition Act 1964 within bracket the 1964 Act, followed by
Page 44.
another order dated 28/7/2026 under section 4 within bracket 1 of the 1964 Act. Section 3(1) in read with Rule 4 of the Assam Land and read with Rule 4 of the Assam Land Requisition and Acquisition Rules 1960
Same year, 64. 64.
in Form C, are followed by post by the order dated 6/5/2026. The opposite party number 5 had requisitioned a parcel of land measuring 211 bighas, 1 katha, 19 lessas. Post up. By the order dated 6/5/2023, the petitioner, sorry, the opposite party, that's petitioner, being the owner in occupation of the said parcel of land, was directed to surrender or deliver possession to the opposite party number deliver possession of the parcel of land. So in the order dated 6/5/2026, passed under section 3(1) of the 1964 Act, the purpose of quote unquote acquisition of land was shown as quote setting up of industrial estate of Numaligarh Refinery Limited, unquote. Surrender possession within 10 days from the date of service of the order. Post up. Para, agreed by the order dated 6/5/2026 in Form B under section 3(1) of the 1964 read with Rule 4 of the 1964 rules, the opposite party number 1 that's writ petitioner has preferred an appeal before the state government on 29/05/2026 under section 3 within bracket 3 of the 1964 Act, contending that the conditions set forth in section 3 within bracket 1 of the 1964 Act were not met for issuing the order dated 6/5/2026. First off, the repetition is preferred with a contention that without the final decision of the state government in the appeal, the opposite party number 5 as the authorized person of the state government could not have issued the order dated 28/6/2026 under section 4 within bracket 1 of the 1964 Act. Post off. As the appeal preferred by the opposite party number 1 that's petition before the state government on 29/5/2026 was not disposed of at the time, till the time of preferring the writ petition. There is no mention of the appeal in the prayer.
We are also for setting aside that, Your Lordship. For disposal of the appeal, we have to pray.
A direction. No, the prayer has been made for setting aside of the order dated 28/7/2026, passed by the opposite party number 5 dash opposite party number 5, that is the collector. Collector, district commissioner,
District Commissioner.
district
Collector.
commissioner.
He's respondent number 4, Your Lordship, when they read petition.
No, we
Oh,
are
yes,
passing
sir,
the order
sorry.
in I,
Sir.
that is district commission. Kamrup, or Golaghat. Golaghat. Full stop. In the section, subsection 3 of section 3 of the 1964 has provided for an appeal when the order for requisition is made by any authority other than the state government. Full stop. As per subsection 3 of section 3, when the order for requisition is made by any authority other than the state government, any person interested in the land, within 30 days from the date of service of the order, may appeal to the state government, and the decision of the state government in such appeal shall be final. Full stop. Paragraph. It is relevant to refer to for consideration of this application for implementation. It is relevant to refer to subsection 1 of section 3 of the 1964 Act, which states as under para. From a reading of section 3(1), the purpose of in section 3(1), the purposes for which requisition of land can be made are listed, are mentioned. First of para. In this interlocutory application, the applicant has mentioned that the parcel of land has been requisitioned for the purpose of acquisition for setting up the industrial estate of Numaligarh Refinery Limited, and it is for the benefit so it is ever that it is for the benefit and proposed, it is for the benefit of the applicant. The parcel of land has been sought to be requisitioned and acquisition, and therefore it is a necessary and proper party to in the proceedings of the writ petition, of the accompanying writ petition. So it is ever that any order passed by this court in respect of the requisition/acquisition proceeding would directly and substantially affect his rights, interest in the proposed project. First of it is from from the statements and averments made in the instant application and are read with the purposes for which a parcel of land can be requisitioned as outlined in section 3(1) of the 1964 Act. It does not emerge that the present applicant is a proper party, not to speak of much less a necessary party in the proceedings of the accompanying writ petition, wherein the petition opposite party number 1, the writ petitioner, has essayed an order dated so and so, passed under section 3(1) of the 1964 Act in Form C. So therefore, this court finds no merit in the instant interlocutory application for implement and result in the same stance dismissed. Next. Third, Mr. D. Senapati, learned counsel for the petition. Mr. A. Aforesaid, learned standing counsel, Revenue and Disaster Management Department for the respondent number 1, 2, and 3. And Mr. N. Goswami, Junior Government Advocate Assam, for the respondent number 4, 5, and 6. Close to. Fair. Eleven 2026 or second paragraph. Third paragraph. Fourth paragraph. When the requisition was listed on 11/8/2026, the learned standing counsel, Revenue and Disaster Management Department, had sought time to obtain instruction as regards the status of the appeal, stated to have been filed by the petitioner before the state government on 29/5/2026. Today, Mr. Authorised, standing counsel, Revenue and Disaster Management Department, has submitted on the basis of instructions received from the state government in the Revenue and Disaster Management Department that the appeal filed by the petitioner on 29/5/2026, appeal filed by the petitioner under section 3(3) of the 1964 Act on 29/5/2026 is presently pending and is yet to be disposed of. Para. In the at this stage, comma, section 3 of the 1964 Act are for the purpose of appreciating for the section 3 of the 1964 Act as provided as under. We did look it. Para. In the order passed under section 3(1) and the order passed under section 4(1) of the 1964 Act, a parcel of land measuring 211 bighas, 1 katha, and 19 lesser is involved. Full stop. As per section 2D of the 1964 Act, comma, quote unquote, owner means proprietor or patta holder and his co-sharer, full stop. It is the contention of the petitioner that it is the owner of the said parcel of land measuring 211 bighas, 1 katha, and 19 lessas. Full stop. Para. When the order under section 3(1) is passed by, is not passed by the state government and is passed by any person authorized in that behalf by the state government, comma, the person affected by such an order has a right to prefer an appeal under before the state government under section 3 within bracket 3 of the 1964 Act. Thus, Commander Statute has given a right to the person, including the owner, person, including the owner, including an owner, whose rights are affected by the order under section 3(1), a remedy to apply to the state government, and the state government has to decide the matter and pass orders affecting the right of the appellant. Full stop. Though an appeal is not an inherent right, but a statutory right. Appeal is not an inherent right, but a statutory right. First of all, a statute provides such a right to appeal, comma, such right to appeal cannot be illusory. Full stop. In the appeal, para, the specific contention, the specific ground urged, it is seen that in the appeal filed before the state government by the petition on 29/5/2026, the main ground urged is that the purpose for which the order under section 3(1) has been passed by the district commissioner Golaghat as an office, as a person authorized in that behalf by the state government, does not fall within the scope and ambit of section 3(1) of the 1964 Act. Full stop. Para. As it is submitted, that as it is submitted, that the appeal under section 3(3) is yet to be disposed of by the state government, whose decision is going to be final, the continuation of this present proceeding, writ proceeding, in the considered view of this court, and this court is of the considered view that since the appeal is pending, this repetition is not to be proceeding of this repetition is not would not be it would not be proper to continue the writ proceeding in a parallel manner. First off. The court is conscious of the view that if the authorized officer, on the basis of the order passed under section 4(1) of the 1964 Act, takes over possession under section 4(1) of the 1964 Act, before the appeal is decided, and changes the nature and character of the parcel of land, then the right of the petitioner is going to be impacted, even if the order to be passed by the state government in the appeal goes in favor of the petition. Appellant. First of para, considering in the above obtaining fact situation, this court is of the considered view to balance the equities. The order under section 4(1), order dated 28/7/2026, passed under section 4(1) in Form B, is to be kept in abeyance till the decision of the state government passed in the appeal, which is presently pending before it. Post of. It is therefore directed, the repetition is disposed of. A direction to the state government to dispose of the appeal filed by the petitioner on 29/5/2026 as expeditiously as possible, and the order passed in the appeal. And and the order passed in appeal shall be communicated to the petitioner immediately thereafter. Full stop. The order we pass in the appeal. Sorry, the order dated 28/6/2026 passed under section 4(1) will abide by the decision taken by the state government in the appeal. And the order under section 4(1) shall remain in abeyance till that time. Most of the parties are to maintain status quo existing as on today as regards the parcel of land measuring 211 bigas so and so. Till the decision made in the appeal, as mentioned here above. Full stop. With the observation made and directions given over, the writ petition is disposed of. There shall, however, be no order as to cost.
Your Lordship, the impugn order on the last line has been stated as 28/6. It ought to be 28/7.
28/7.
Your Lordship, one more. Dispose of the appeal by affording me an opportunity of hearing. Otherwise, they may read it without.
By affording an opportunity of hearing to the applicant.
Much obliged.
Supplementary list, item 18.
What is the notice? Your name? Sakinur.
Second, Lordship.
What is the notice?
Notice, Lordship, will find at page 17, Lordship. 17.
That's first.
Pera. Hard, Mr. A. Islam. Learn a counsel for the petition. Mr. Ian Bodule, learn it. Standing Counsel Revenue and Disaster Management Department for respondent number 1 and Mr. N. Goswami.
For 23.
Junior Government Advocate Assam for the respondent number 2 inch. Post. The case of the petition appears 24 of Sabbath. How much land,
Lordship, land
area?
1 bigha 3 kata 8
less,
lesser. Out of 6 bigha 4 kata 5 lesser.
Page 24 of Sabbath. Same duck number?
Same that number, Lordship.
1214.
Lordship.
Village Adabari Part 1.
Lordship.
So main area is 6 bigha, 4 kata, 5 lesser.
5 lesser. And Lordship, when this notice under Rule 18(2) was issued, the subject plot of land was already converted into patta land. So Lordship,
I have understood. Did you make any application for settlement?
Lordship. Page 27 to 20, page Lordship, you will find page 20. 18 to 20, Lordship.
Where is that Jamabandi?
Jawamati Lordship will find that
That
page,
Vivekananda.
page 21. And vernacular at page 22, Lordship. Jawamati,
20/03/2025.
Lordship.
On that date, it
On
has
that
been.
day.
Pass number para last for likhib. Pass number para last for. The petitioner has further contended that when on the date of issuance of the impugned notice in August 2025 for vacating the parcel of land measuring 6 bighas, 4 kathas, 5 lesas under government dag number 1214 as government land under dag number 1214. The said parcel of land has already been converted into periodic patta land on 20/03/2025 by settling it in favor of and in favor of Vivekananda Rock Memorial and Vivekananda Kendra Kanyakumari, comma, the respondent number 3 does not have the authority and jurisdiction to issue the impugned notice. Full stop. Para 5 or last stop. Para 6. তাৰপিছত লিখিব 7 হা অকল 18(2) আছিল তো rule 18(2) and rule 18(3) of the settlement rules framed under begins of rule 18(2) আছে না rule 18(3) to quote কৰি দিব Mr. Islam, learned counsel for the petitioner has submitted that one of the 4 notices, comma, Azizul Haq, one of the 4 notices in the impugned notice served or dated 00/08/2025. Etu para 8 hobo. Azizul Haq had earlier approached this court by challenging it in a writ petition, WBC number 6119/2025. First off, after hearing the parties, the said writ petition was disposed of by an order dated 31/10/2025. Observing that by setting aside the impugned notice bearing number DBC 07 so and so, dated so and so, issued by the respondent number 3. Posted. Also para 8, para 9 হয়ে যাবে। Such a para 9 or last of para 8 to 9 হয়ে যাবে, such my pencil লেগে যাবে। And sorry, তাতে and তার last of to 8 to 9 হয়ে যাবে, 9 or last of. An opportunity of similar opportunity is to be given in case a notice is issued under Rule 18(3) of the settlement rules also. Full stop. And 9 to 10 হয়ে যাবে। 10, 11. As from the records of right, as from the Jamabandi, you didn't make records of right, comma annexed to the writ petition as annexure 5, as nothing from the. It primarily emerges that the parcel of land measuring 6 bighas, 4 kathas, 5 lessers, under DAG number government under DAG number 1214, in respect of the parcel of a periodic patta had already been issued periodic patta number 914 within bracket new had already been issued pursuant to an order dated 20/03/2000, pursuant to an order bearing number ECF 621917/2025/52 of the Revenue and Disaster Management Department, Government of Assam. Full stop. It has thus primarily emerged that the impugned notice, when the impugned notice dated 00.08.2025, that likha hai say to style of impugned notice bearing number so and so was issued to the notices, 4 notices, including the petitioner, in August 2025. Under section 18, Rule 18(2) of the settlement rules, the parcel of land had already been converted to periodic patta land. Full stop. In such view of the matter, this court is of the view that the respondent number 3 This court is of the view, in such view, this court is of the view that the respondent number 3 would not have derived any authority and jurisdiction to issue the impugn notice under Rule 18(2) of the settlement rules. So therefore, the court is of the view that the impugn notice numbers bearing number so and so dated so and so is beyond the authority and jurisdiction of the respondent number 3. Full stop. Therefore, the same is that therefore it is another region. Therefore, comma, it is this ground also makes the notice, impugn notice, unsustainable in law. Also. While parting with comma, it is made clear that setting aside and passing of the impugn notice shall not preclude the competent authority to proceed against the petition following due procedure of law if the petitioner is allegedly found to be in unauthorized occupation of the parcel of land measuring 1 biga 3 katha 8 lesa. So it will be civil suit only.
Not civil.
It will be civil suit.
Remedy lies in the civil court.
So it will be civil suit. Will you say so?
No.
Just
Daily list for admission, items 2 and 3.
May it please the lordships, Mr. Kyal is not in court, lordship.
Huh?
Can it be taken after some time, lordships? Or lordship, they can start, lordship.
up to you.
Lordships.
Lordship, this was the matter regarding
Just a minute.
Lorships.
We got for you. Okay. Are you listening? Hmm? I tend to forget easily, Mr. Kanodia.
Lorships, I will give you a brief overview, Lorships. I prepared this written notes, therefore, Lorships, I've handed over them. It's a just summary of the entire issue and the points there. Lordship, the issue here is, Lordships, regarding my claim of refund of education cess and secondary higher education cess under the Northeastern Industrial Policy. Lordship, I had set up a unit in 2009 and as per the notification 20/2007 and Lordships 20/2008, I was claiming refund of duties paid in cash. There are two aspects, Lordship. One is Senvet credit and one is cash, which is PLA. So when I purchase raw materials,
What is the full form of PLA?
Lordship, permanent ledger account. Lordships. So Lordships, the scheme of the statute was that whatever amount I pay through debiting the PLA, I am entitled to a self credit of that. So I had claimed those refunds, Lordships, and 2008 the notification stood amended to say that basis a percentage of value addition that you do. So in my product was falling under chapter 44. For that, the value addition percentage was fixed by the notification as 36%. But there was another provision in the notification that if your value addition is more than that, then you can apply to the jurisdictional proper officer basis the CA certificates and he will assess that. So my first claim, Lordships, for November 2009, it started with November 2009 when the proper officer visited my establishment and held me to be a eligible unit under the scheme, but stated that because you have not utilized entire SENVET credit and claim refund, your refund is liable to be rejected. That was only for November 9. Against that order, Lordships, the department preferred an appeal before the first appellate authority, Commissioner Appeals, on the ground that the observation of the assistant commissioner that I am an eligible unit under the scheme is disputed. The learned Commissioner Appeals ruled against the department, held in my favor, no, I am an eligible unit. The department then, Lordships, carried that particular matter to the tribunal, Honorable Sestate, Calcutta, Eastern Zonal Bench. The tribunal also dismissed the revenue appeal, Lordships, and held the finding of the proper officer that I am an eligible unit is correct. Lordship, that was brought by the department to the division bench of our Honorable High Court here, and the Honorable Division Bench also, Lordships, ruled, answered the questions of law against the revenue in my favor. In the midst, Lordships, all my applications for 9, 10, 10, 11, 11, 12, 12, 13, I had been filing those applications before the jurisdictional officer. Now, after this division bench order, the jurisdictional commissionerate fixed a special rate of duty under the notification 20/2008 and sanctioned my refund for the basic excise duty along with interest. And in that order, it was recorded, Lordships, that the SSE has filed all the refund claims during this period, but because of eligibility issue, which was carried by the department till the division bench, therefore this refund was not processed. No other reasons.
Let us have that.
Lordships. Lordships, the division bench order, Lordships, is at page 63. Lordship, want to see the sestate order, Commissioner Appeals, every order?
Let us go chronologically.
Lordships, then the first order, Lordships, will get at page 44.
Okay.
Page 44, Lordships, is the order in original dated 21/4/2010. Lordships, the para number 4, page 45. The SSE has filed refund claim of rupees this, including ECES and SHE cess for the month of November 2009 under notification number dated this. This was my first claim after my commercial provisions. Lordship, then Lordship, the operative part, may I take your Lordship to the operative part?
Just a minute. Yes.
Lordships, the operative part, Lordships, is at Lordships para number 12. May I please, page
Yes.
number 47.
Yes.
In view of the aforementioned facts, circumstances, and amendment made in notification 20/7 by notification 20/2008 and notification 38/2008, I find the SSE messes this having its factory at this place is eligible for refund of duty under notification 20/2007 dated this, but the SSE has sufficient SENVET credit available to them unutilized at the end of the month under consideration. Therefore, their refund for the month of November 2009 is nil in terms of principal notification. So, Lordship, two findings in this. One, I am held to be eligible, but because I have not exhausted SENVET credit, I am not entitled to the refund. This was the principal observation in the impugned order, Lordships. Lordship, this order was carried to appeal by the revenue, which is starts at Lordship, appeal order is at page 49, dated 2/8/2012.
Yes.
Lordship, the operative part of this order, Lordships, kindly take, Lordships. Para number 7 at page number 56.
Just a minute. Page.
Lordship, page 56, para number 8, last para. May I please, Lordship?
Yes.
Irrespective of the above findings on general eligibility of notification to the respondent, I do not feel it necessary to interfere with the impugned order not granting the benefit of notification 20/2007 to the respondent for the reason that the condition of first utilizing Senvet credit to the full extent of duty chargeability has not been fulfilled. Accordingly, department appeal is rejected, upholding the impugned order. So, Lordships, my eligibility was not disturbed by the Commissioner Appeals, but the claim for November 2009 was also not disturbed, stating that Senvet credit was there. So the appeal of the revenue was rejected, Lordships.
So against the denial, you did not file any appeal?
No, Lordship, because that was the law. How it stood, it was that law, Lordships. I could not have. Lordship, this again was challenged by the department before the Honorable Tribunal. At page 58 is the order of the Honorable Tribunal, Sestet Eastern Zonal Bench, Lordships.
Yes.
Lordships, the operative part of that order, Lordships. Para number 7 at page number 61.
Yes.
We have gone through the findings of the learned Commissioner Appeals in the impugned order and the documents placed before us, which are evident that the respondent has established a new unit, although at the same site. In that circumstances, we do not find any infirmity in the impugned order, and we hold that the respondent is entitled to the benefit of exemption notification dated this. In that circumstance, the impugned order is upheld and the appeal is dismissed. So again, Lordship, my eligibility was upheld by the tribunal. So now this was challenged by the department before the division bench of Honorable High Court, and that judgment is, Lordship, page 63, wherein the substantial questions of law, it was held that no substantial question of law arises. Lordship, page 70, para number 16.
Yes. Para number.
Lordship, page 70, para number 16, 16. The materials available on record reveal that the Assistant Commissioner, after visiting the respondent factory and after inspecting the documents, recorded a specific finding that the respondent unit is a new industrial unit which commenced commercial production after 147. Apparently, the said finding of fact is based on the material and rightly has not been interfered by the Commissioner Appeals as well as by the Sestet. In view of the above discussion, we are of the view that no substantial question of law arises, hence the appeal is dismissed. Now, Lordships, in between this, in my written notes, Lordship, I have given a table at page number 2. The written notes are just handed over today, Lordship.
Yes.
Lordship, page number 2, Lordships. Lordship, first is 21/4/2010, which I have taken your Lordships to the order, the first order. Order dated 21/4/10. Lordship, next line, 2010 to 16, between this period, I had filed my refund claims with the department, and department had issued me 23 protective show cause notices because they were disputing my eligibility, that I am not an industrial unit at all. So for this period, they issued me 23 protective show cause notices.
Any show cause is available on record.
Lordship, I have attached the order which they have, through which all their show cause has been nullified. Lordship, may kindly take page number 71 after the division bench order. Page 71, Lordships.
Yes.
Lordship, page 72, Lordships. Annexure A, a list of notices is given.
Just a minute.
Lordships.
Yes.
Lordships, here in page 72 and 73, 23 show cause notice details have been extracted by the commissioner, which has been adjudicated through this order. Lordship, now Lordship, brief facts, Lordship, may the observations which has been recorded, Lordships.
Let us understand and from where he has dealt with this 23 notice.
Lordships, that starts at, Lordship, page 77, paragraph number 15.
Okay, let us see from here.
From the starting, I will place, Lordship.
15. The
Lordship,
other part is previous part is with regard to
the same, the November 2009. Paragraph 15, Lordship, in addition to the above, and in order to protect the government revenue, department issued subsequently 22 numbers of periodical protective demand show cause notice statement were issued by the department as detailed below. Lordship, respective periods and amount has been mentioned. This was on the basis of my claim of refund made. They had not given me the refund on the ground that my eligibility is pending before this estate. So they issued me protective show cause notices.
okay.
Lordship, para 16. Thus, it appears that the 23 numbers of demand show cause notices statements were issued to recover the erroneous refund taken by the noticee amounting to rupees this, covering the period April 10 to January 16 under section 11A, along with interest for delayed payment of excise duty accrued thereon.
Now what is this 11 lakh?
Lordships,
This 11 because table shows
Lordship,
9 crore 24 lakh 90,000.
that is for 22 notices. For the first notice, it is 11 lakh. Lordship may take para number 14, it will be clear. Paragraph 15, Lordship, says it is 22 notices in paragraph 15.
22 notices.
Yes, and for the 11 lakh is the above para 14. For April and May. So they have combined one and then this. 11 lakh 27,815.
So page 72 or
Page
23.
23, Lordships. This is total 23.
Page 72 all 23.
All 23.
Total figure is 99 crore.
9 crore 36 lakh 18,301, Lordships.
That is your claim.
That is my claim.
Okay. So basically 72, it includes all 23.
Lordships. In the table, 23 is given also, Lordships, in the serial number.
Right. Page 72, all 23.
All 23 is there, Lordships.
So no need to go to paragraph 14 and 15.
Lordship, no need to go, Lordships.
Okay. Then 16.
16. 16, Lordship. Thus, it appears that 23 number of demand cum show cause notices were issued to recover the erroneous refund taken by the noticee amounting to this rupees. 17. The Commissioner Appeals, Customs and Excise White OIA, number this dated 2/8/12, had rejected the department appeal upholding the eligibility order wide OIO number this, which your Lordships had seen, the Commissioner Appeals order. It is referring to that. Being agreed with the order of the Commissioner Appeals, the department preferred appeal before Sestate Kolkata. However, the said appeal filed by the department was dismissed by Sestate Kolkata, while order number dated 15/6/23 and hold that the respondent is entitled to. This, Lordships, I have seen, Lordships has seen this order. 19. Being aggrieved with the order passed by the Honorable Session Kolkata, the department preferred appeal before the Honorable Gauhati High Court. The Honorable Gauhati High Court, was either dated 8/12/13/23, framed the following substantial question of law. Para 20. The Honorable Gauhati High Court, by order judgment dated 25/10/24, viewed that no substantial question of arises in the present appeal and hence dismissed the appeal filed by the department. This, your lordships, is the division bench order. The above order 21, the above order dated 25/10/24 of the Honorable Gauhati High Court has been accepted by the competent authority. That means, their lordship, they have not preferred any appeal before the Supreme Court office. As intimated by Superintendent Law Legal Office of the Commissioner, while later dated this. In view of the above, all the above 23 show cause notices which were kept in call book have been taken out for adjudication. Out of these 23 cases, there are a number of notices on the same issue which can be decided by different authority adjudicating officers at different levels. Here, AC, DC, JC, ADC, and Commissioner. And on the basis of monetary limit specified by the board, circular dated 27/7/97 as modified by circular dated 13/8/97. Out of 23, there are 8 number of cases on the issue to be adjudicated by Commissioner on the basis of monetary limit. As per CBC circular dated 9/12/97, where simultaneously different cases of same notices involving the same issue are due to be adjudicated in a commissionerate, all such cases will be adjudicated by an officer competent to decide the case where due to involve is the highest amount. Therefore, it is decided to adjudicate all 23 cases together in a single order at the highest level of commissioner.
That is commission.
That is the commissioner. So, commissioner has passed this order. Now, lordships, after again the same history is repeated in discussion and finding, lordships. The relevant part, lordships, para 29, page 84. The same analogy of events has been repeated, lordships. Page 84, para 29. In the discussion finding starts from this, lordships.
Page.
Page 84, para 29. The department has not filed further SLP in the Honorable Supreme Court against the said order of the Honorable Gauhati High Court and accepted the order dated 25/10/24 by the competent authority as intimated by the Superintendent Law Legal, while later dated 22/1/25. In the meantime, it is learned that the competent authority, by its order dated 21/1/25, has already fixed and allowed the special rate representing the actual value addition in respect of plywood, blockboard falling under Chapter 44 of the tariff in terms of Notification 20/2007 as amended by Notification 20/2008 and 38/2008. It reaffirms the findings of the Assistant Commissioner, Central Excise, Dibrugarh, in the OIO dated 21/4/10 that the notice is eligible to avail. This order I will place, lordships. It is the next order in the. In these circumstances, I find that the findings of the Assistant Commissioner, Central Excise Dibrugarh Division in the OIO dated 21/4/10 that the notice is eligible to avail the exemption under notification number this as amended is liable to be upheld. I also find that the notice is rightly availed the benefit of exemption by way of refund of self-credit in terms of the said notification from 10/11 onwards. Accordingly, I find that the protective demand which amount were availed as benefit of exemption by way of refund in terms of the said notification by the noticee involving aforesaid 23 show cause notices under section 11A as amended are no longer maintainable and liable to be dropped. Simultaneously, demand of interest under 11AB of the Excise Act is also liable to be dropped. So, Lordship, all the 23 on the self-credit issue, by this order, the protective show cause notices were dropped. Now, Lordship, in this amount of 9,36 lakh was only for basic excise duty. It did not include cess and higher cess. Cess and higher cess, lordships. Cess, E-cess and SHE cess. Education cess, lordships.
And what is the
And
other one?
secondary and higher education cess, SHE cess. So Lordship, once the SSC realized this, because this was what they have been claiming as self-credit was only excise duty, then in the mid, a Supreme Court judgment came in case of SRD nutrients. On the basis of that, Lordship, we had handed over a letter dated 17/12/2000.
Let us see next order, that special rate, thereafter we'll go.
Lordship, special letter. Lordship, next order starts with Lordship, page 86.
Yes.
I am placing Lordships from the first paragraph only because that will make things. Messrs. Duroply Industries Limited address this, formerly known as having central excise registration, engaged in manufacture of plywood block board under chapter 44 of the first schedule of the Central Excise Tariff Act, has applied to the Commissioner CGST Central Excise Dibrugarh for fixation of special rate of value addition for refund of excise duty as per para 3 of notification 20/2007 as amended by notification 20/2008 and notification 38/2008 for financial year 9-10, 10-11, 11-12, 12-13, 13-14 and 14-15 by their application dated 3/9/24 along with copy of final order dated 17/5/24 passed by Sestet Kolkata and excise appeal this. Now Lordship, again that history is repeated. And may I skip that, Lordship? Or I'll place.
Who is that regarding special rate?
Lordship, that is notification 20/2008, my compilation, Lordships,
20?
bar 2008. My compilation, Lordships, page number 21. In exercise of powers conferred under subsection 1 of section 5A of the Central Excise Act, the central government being satisfied that it is necessary in the public interest to do so, hereby makes the following amendment in notification of Government of India number 20/2007 dated 25th April, which was published in Gazette dated 25th, namely in the said notification. 1. In the preamble for the words and figures to the amount of duty paid by manufacturer of goods other than the amount of duty paid by utilization of Senvet credit under the Senvet credit rule 2004, the words to the duty payable on value addition undertaken in the manufacture of the said goods by the said unit shall be substituted. So Lordship, earlier it was self credit and now they have given another proposal of value addition. For paragraph 2, 3, 4, the following shall be substituted, namely that duty payable to A, the duty payable on the value addition shall be equivalent to the amount calculated as a percentage of the total duty payable on the said excisable goods of the description specified in column 3 of the table below and falling within chapter of the said first schedule as are given in the corresponding entry in column 2 of the said table at the rate specified in the corresponding entry in column 4 of the table. So if this table specified, if you are falling under this particular chapter, then this is the value addition that we are thinking is a base value addition. So Lordship, my chapter was chapter 44. There was no specific chapter. Therefore, I will fall under serial 12, any chapter. And where the rate was, where the value addition was 36% as per the notification. Relevant paragraph would be 2D, page 22.
Yes.
2D. Notwithstanding anything contained in subparagraph 2C, the manufacturer at his own option may take credit of the amount calculated in the manner specified in para 2A in his account current maintained in terms of excise manual of supplementary instructions issued by the CBIC. Such amount credited in the account current may be utilized by the manufacturer for payment of duty in the manner specified under Rule 8 in subsequent months, and such payment shall be deemed to the payment in cash. Then Lordships, this is regarding how 2A is to be done. Now Lordships, kindly takes 3. This is the procedure in paragraph 2D. Now, Lordship, paragraph 3.1. Notwithstanding anything contained in paragraph 2A, which specified 36%, the manufacturer shall have the option not to avail the rate specified in the said table and apply to the Commissioner of Central Excise or the Commissioner of Customs and Central Excise, as the case may be, having jurisdiction over the manufacturing unit of the manufacturer for fixation of special rate representing the actual value addition in respect of any goods manufactured and cleared under this notification. If the manufacturer finds that 4/5 of the ratio of actual value addition in the production or manufacture of the said goods to the value of the said goods is more than the rate specified in the schedule. So this was an option, Lordships. 36 is what the statute prescribed. But the government gave an option if, as per your own calculation, your value addition is more than 36, you apply to the commissioner for fixation of special rate as a percentage. For the said purpose, the manufacturer may within 60 days of the beginning of financial year make an application in writing to the Commissioner of Central Excise or Customs, as the case may be, for determination of such special rate, stating all relevant facts, including the proportion in which materials or components are used in production or manufacture of goods, provided that the Commissioner of Central Excise or Commissioner of Customs, as may be, if he is satisfied that the manufacturer is prevented by sufficient cause from making the application before the aforesaid time, allow manufacturer to make application with a further period of 30 days. Provided further that the manufacturer supports his claim of special rate with a certificate from his statutory auditor containing an estimate of value addition in the case of goods for which a claim is made based on the audited balance sheet of the unit for the preceding financial year. So, Lordship, now this will be reflected in this special rate order. Page 87, Lordships may take serial number 5.
Yes.
In response to the office letter dated 23/12/24, the applicant submitted following documents in support of their claim of value addition. Certificate of value addition for financial year this by CA from this. Audit report of the books of accounts for financial year 9-10 to 14-15. Copies of ER1, 23A, 23C, etc. for financial year this, along with signed copy of trial balance. Copy of certificate of incorporation pursuant to the name change. Applicant also submitted copy of application filed for fixation of special rate for financial year this, which was filed on this respective dates. Then discussion and finding, Lordships. And in the discussion finding, all these tables, Lordships, kindly takes page 88, the table in the page 88. Last percentage of value addition, 76. So, Lordship, statute had fixed 36. I had, my data was more. So, therefore, this is how for each of the financial year up to 13-14, my special rate was fixed by the Assistant Commissioner. Lordship, relevant paragraph would be next, Lordships. Paragraph number 10, page number 91, wherein my final rates after verification, what I submitted and what department then finally passed, is at para number 10, page 91. For each of the financial year, they have determined the rate, Lordships, and which is summarized, Lordship, at para number 12, page 93. So by this order, Lordships, my special rate got fixed for the period. Now, Lordships, in the meantime, there came the judgment of the Supreme Court in the case of SRD nutrients, which Lordships will file in the compilation at page 47. Judgment dated 10th of November 2017. . Just the penultimate paragraph of this judgment at page 65, just for once, then I will. Page 65, Lordships. Para number 27. For the aforesaid reasons, we allow these appeals and hold that the appellants were entitled to refund of cess and higher education cess, which was paid along with excise duty. Once the excise duty was itself was exempted from levy, there shall be no order as to cost. So, Lordship, after this judgment came, because we during all this time, that 9 crore 36 which your Lordship has seen, it was basic excise duty only. But we had been paying education cess 2% and 1% SHE cess also. So after this judgment, Lordships, we had handed over a application dated 22nd November 2019 to your Lordships. 3 pages were there. A table was there, Lordships, and then two letters. No, Lordship, during the course of earlier hearing. May I?
Just a minute.
See, I have one copy.
Listen.
I apologize, it is torn from above. Lordship,
Yes.
kindly take the second page, Lordships. First is the letter of the department. Second page is my letter, Lordships. Lordship, I write to the Assistant Commissioner stating claim of self-credit as per Supreme Court order dated 10/11/17 in civil appeal number this. The Honorable Supreme Court, white order, captioned order, has decided that the appellants were entitled to refund of cess and higher cess which was paid along with excise duty. We have commenced commercial production with effect from this, and accordingly, we are eligible for the refund of cess and higher cess as permitted by Supreme Court by the aforesaid order. Accordingly, we hereby claim the cess and higher cess paid by us through PLA. The total amount as per calculation comes to rupees this for the period 1st April 10 to 28 February 15. Now, Lordship, along with this, there was a chart. We gave a chart. Now, what did the department stated, Lordships, on 17/12/19? This is the crux of my case, Lordships. Department returned back my application.
Just a minute.
Lordships.
So this is after that fixation of special value.
Fixation of special Lordship in 25.
Huh.
Because it was pending before the tribunal for more than 7 years.
Just a minute.
Lordships.
So it was after order in original.
After order in origin. Yes, Lordship. After in order in origin. After order in appeal also, Lordship. Before tribunal.
Before tribunal.
Before tribunal. Tribunal came in 23, Lordships. 15/6/23.
Hmm.
Order in appeal came in 2/8/12.
12. So after
After appeal order. Therefore, what they write, Lordships, kindly seize this letter. It is in my facts of my case, Lordships. I'll place this letter, Lordships. Claim of refund as per Honorable Apex Court order dated 10/11/17 subject. Please refer to our application for e-cess and higher e-cess as per Honorable
no.
Apex Court order.
First page. First page.
Lordship, first page.
Okay.
First.
Yes.
Lordship. Subject, claim of refund as per Honorable Apex Court order dated 10/11/17. Sir, please refer to your application for refund of education cess and higher education cess as per Honorable Apex Court order dated 10/11/17 in matter of message this. It has been found that your eligibility of benefit of exemption notification 20/7, which is a pure prerequisite for availing the benefit, has been challenged by the department before the Sestate, Kolkata, The case is still pending and registered under Central Excise Appeal this. Therefore, your claim is hereby returned. So, my cess claim, though accepted as per the law prevailing at that moment of time, but returned on another ground that my eligibility department is disputing. There was no dispute as to my claim of cess lordships. The only dispute was that my eligibility they have been disputing since 2010. Now, lordships, so this they returned. Now, lordships kindly takes the impugned order, which is the subject matter of challenge before your lords, which starts at page 95. Page 95. After fixation of special rate lordships, they processed my excise duty refund along with interest. But they rejected my claim of cess and higher cess, citing another judgment of Supreme Court. Lordships, page 95, order in original 16 dated 11/2/25. In the top middle after the small table it is there. Lordships. Page 90,
Yes.
page 96, Lordship, it's again the entire factual history and the facts have been narrated, Lordships. Discussion finding starts at page 98.
Page 98.
Page 98, discussion finding, Lordships.
Huh.
May I place this? I have carefully gone through the refund claim along with the SSC submission special rate fixation order, wide number dated 21/1/25, passed by Commissioner, records available with the department legal provisions in respect of the instant case. I find para 2 of the now notification has been extracted, Lordship, which I have shown your Lordship, the board notification. Lordship, para 15 now, Lordships may take directly because before that everything is an extraction of notification. Para 1/5.
Yes.
I find that the applicant had submitted application for fixation of special rates for financial year 9/10 to 14/15 on these dates, respectively. Further, I find by order number 2 dated 21/1/25, Commissioner has fixed the special rates at 68 for each of the years under the provisions as amended. 16. I find earlier show cause notice wide dated 16/4/10 by the Assistant Commissioner was issued to the SSC by rejecting the self-credit for the period this due to non-eligibility of the exemption benefit in terms of notification. In order to protect the revenue, the department further issued another 22. Again, that fact has been narrated, Lordships. I find that all para 18, I find all charges as specified in the above said 23 number of show cause have been dropped by the Commissioner wide order dated 29/1/25 from financial year 10/11 onwards in pursuance of the Honorable High Court, Gauhati High Court order dated 25/10/24. 19. It is pertinent to mention here that by OIO number 4 dated 21/4/10, the Assistant Commissioner has passed eligibility order to avail benefit of exemption in terms of 20/2007, which is also upheld by SESTET by final order dated 15/6/23 and the Honorable Gauhati High Court order dated 25/10/24, which is accepted by the competent authority as specified in the OIO dated 29/1/25. On the basis of the submitted documents and records available with office, I find SSC has taken self-credit during the material period, financial year 9/10 to 14/15. As such, I proceed to redetermine the amount refundable to the SSC for the period April 9 to March 15 on the basis of submitted documents, available records, along with the department and special rate fixation order dated 21/25 by the Commissioner, read with notification 20/2007. Now, Lordship, they have prepared a chart for each financial year. What was my self-credit? What should be as per my value addition and the differential. Lordship, may kindly take the summary at page 103, para 22. Summary of all 5 financial years. So they determine refund due as 2,45 lakh, Lordship, in the total, grand total for these years. This is again, Lordship, basic excise duty only. From the above table, it is found that the SSC is eligible for refund of rupees 2 crore this in accordance with the special rate fixation order. 24. The SSC has also claimed refund of e-cess and higher education cess, stating that the cess amount is also refundable along with excise duty amount whichever applicable. They have submitted a copy of order dated 10/1/11/17 issued by Honorable Supreme Court, when it is declared that the cess is to be levied on calculate on the aggregate of all excise duties. Therefore, it is clearly referred that when there is no excise duty payable as it is exempted, there would be no education cess as well. I have gone through the matter of refund of cess and education cess and secondary and higher education cess, and I find that SSC has submitted an order dated 10/11/17 issued by the Honorable Supreme Court of India to Judge Bench in the matter of SRD nutrients. In the said order, appeals of the party was allowed and held that the appellants were entitled to refund of education cess and higher education cess, which was paid along with excise duty once the excise duty itself was exempted from 26. However, I also find that the Honorable Supreme Court 3-judge bench has also given a judgment dated 6/12/19 in the matter of Messrs. Unicorn Industries, wherein the following decision is made by the Apex Court 43. Thus, it is clear that before the division bench deciding SRD nutrients and Bajaj Auto Supra, the previous binding decision of 3-judge bench in Modi Rubber and Rita Textile were not placed for consideration. Thus, the decision in SRD nutrients and Bajaj Auto are clearly per inquirium. The decisions in Modi Rubber and Rita Textiles are binding on us being coordinate bench, and we respectfully follow them. We do not find any ground to take a different view. Resultantly, we have no hesitation in dismissing the appeals. The judgment of the High Court are upheld. While passing the above order, the Apex Court observed the following. Para 40. Notification dated 9/9/2003 issued in the present case makes it clear that exemption was granted under Section 5A of the Act concerning additional duties under Act of 1957 and additional duties of excise under Act of 1978. It was questioned on the ground that it provided for limited exemption only under the acts referred to therein. There is no reference to the Finance Act 2001 by which NCCD was imposed, and Finance Act of 2004 and 7 were not in vogue. This is very relevant, Lordship, because our claim is of cess and higher cess. 2004 Finance Act brought in e-cess, 2007 Finance Act brought in SHE cess. At the time of Unicorn, at the time of decision of Modi Rubber, these were not in place at all, because that was 1970, Lordship. The notification was questioned on the ground that it should have included other duties also. The notification could not have contemplated the inclusion of education cess and higher education cess imposed by Finance Act of 2004 and 7 in the nature of duty of excise. The duty on NCCD, education cess and higher education cess are in nature of additional excise duty, and it would not mean that exemption notification dated 9/9/2003 covers them, particularly when there is no reference to the notification issued under Finance Act 2001. There was no question of granting exemption related to cess was not in vogue at the relevant time imposed later on, while 91 of the Act of 2004 and Section 126 of Act of 2007. The provisions of Act of 1944 and the rules made thereunder shall be applicable to refund, and the exemption is only a reference to the scope of power to exempt NCCD, cess, and secondary and higher education cess. A notification has to be issued for providing exemption under the said source of power. In absence of notification containing an exemption to such additional duties in the nature of education cess and higher education cess, they cannot be said to be exempted. The High Court was right in relying upon decision of 3-judge bench in court of this court in Modi Rubber, which has been followed by another 3-judge in Rita Textiles. The circular of 2004 issued based on interpretation of the provisions made by one of the custom officer is of no avail, as such circular has no force of law and cannot be said to be binding on the court. Similarly, the circular issued by CBIC in 2011 is of no avail as it relates to service tax and has no force of law and cannot be said to be binding concerning the interpretation of provisions by the court. The reason employed in SRD nutrients, Supra, that there was nil excise duty as such, additional duty cannot be charged, is also equally unacceptable, as additional duty can always be determined and merely exemption granted in respect of a particular excise duty cannot come in way of determination of yet another excise duty based thereupon. The proposition urged that simply because one kind of duty is exempted, other kind of duties automatically fall, cannot be accepted, as there is no difficulty in making the computation of additional duty which are payable under NCGD, education cess, and secondary and higher education cess. Moreover, statutory notification must cover specifically the duty exempted. When a particular kind of duty is exempted, other type of duty or cess imposed by different legislation for a different purpose cannot be said to be exempted.
What is NCCD? Though not involved.
Lordship, it is natural calamity cess. One type of cess only. 28. From the above, I find refund of cess and higher education cess cannot be made, and accordingly the same is denied in sanction in accordance with the above stated. So this is the point of dispute before your lords. I place the judgments in this regard, lordships, what Supreme Court post Unicorn, how it has interpreted our Honorable High Court in couple of matters. But the first point of my argument lies in the fact of this letter, which they returned my application in 2019 before the judgment of Unicorn was passed. I had filed that application, lordships, on 22nd November 2019. SRD nutrients came to be passed on 10/11/17. And Unicorn came to be passed on 6/12/19. So my application is prior to Unicorn. In their letter to me, they have accepted this proposition that your claim is genuine. It is crystallized also. However, because since 2010, we are disputing your eligibility, therefore we are sending you back. Keep your documents with you. That is what specifically their letter dated 17/12/19 states, that your eligibility is pending before sestet. So lordships, from 2010, 21/4/10, the first order original comes, my eligibility decided in my favor. They litigate it till 2025. Till 2020, lordships, sestet order in 23 and division bench our court order in 25th October 24. They lose in all the forums. Now, in the meantime, my claim of cess crystallized with them. Now they are taking a recourse to another judgment to deny me the claim of cess. Nowhere in the entire proceedings they had stated your claim is not crystallized. They have refunded my excise duty with interest. But because of a subsequent change in law, what was important, lordships, to be seen, that as on the date of my claim, what was the law of that land? SRD held the forte, lordships. SRD nutrients was the law of the land under Article 141 at that moment of time. They have not disputed that. Suddenly in 2025, can the department take recourse to a few next judgment of the Supreme Court to deny me a claim which crystallized under the old judgment of the Supreme? So, lordship, first, lordship, that the commissioner appeals, the adjudicating authority and the honorable sestet, and the commissioner, lordship, dropping all the 23 protective show cause notices. This all happened because of the litigation carried by the revenue up to this Honorable High Court. So once all the category of SSCs, lordships, who were claiming the refund, were getting the refund. My particular case, they disputed my eligibility. Now once they dispute the eligibility and it is settled in my favor, can they take a recourse to a subsequent development? When had my refund claim not crystallized, I would have no case, lordships, before this Honorable Court. They don't deny that my claim had crystallized. In their letter, they say, we are only questioning your eligibility.
That letter speaks nothing.
Lordship, that letter has returned.
Your eligibility, returned, simply returned.
Returned, lordship, on the ground that eligibility is disputed. Lordship, sees the date of this letter, 17/12/19.
No, on the claim, they said nothing.
No, lordship, why I say so? Why I interpret that they say? Because 17/12/19, they write this letter. Unicorn came on 6th December 19. Unicorn came on 6th December 19. My application was November 19. They still say, okay, nothing.
Mr. Kandia, you can lower your voice
Sir,
also,
I-
right? Yes.
So, Lordships, the dates becomes important for me, Lordship, because when they issued this letter, Unicorn had come, but they choose not to refer to Unicorn. They simply say, because we are litigating your eligibility, so you
So 17 when unicorn came.
Unicorn came, Lordships, on 6th of December 2019.
6th of December.
Lordships,
They returned it on 17th.
17 days. So this is relevant, Lordships. Now, Lordships, as a litigant, I cannot be worse off because of a departmental litigation. I did not carry any litigation in the entire history of 2010 till 24. They ordered in my favor. They carried it to Commissioner Appeal. They carried it to tribunal. They carried up to division bench. Now,
Now let us have those documents
Lordship.
whereby these two cases have been imposed.
Lordships.
But now it is 1 o'clock.
Lordships.
Now it is 1 o'clock.
Lordships. After this.
How much time you need?
Lordship, half an hour.
2 o'clock, I have a appointed meeting in another court.
So he can continue?
Not so. My
Yes, Mr. Chaudhary.
Yes.
What item?
Actually, I have a matter. Actually, second half I won't be there, Milord. If you also kindly please just 4 and 7.
Mr. Kanodia will take much
I
time.
take some time, it looks like.
It looks like he'll
Yes.
take some time.
Milord, item number 4, I think government has not filed their affidavit. It's a long old matter, Milord.
Regarding only so many other old matters are listed. Second part.
No.
Only 23. If you look at item number 10 onwards, then it. Yes.
I think Milord, he's praying for 10 days time, Milord,
Huh,
not more
2
than
weeks.
that.
Lordship, 2 weeks time.
Yeah, this year is the December, the amendment was allowed till then they have not filed their reply.
Mr. Kane Churil, as senior counsel, yesterday by Miss R. Kakotil and counterpart of petition. So all are state respondents?
Yes.
Okay. Mr. P.K. Metil
Milord,
and
2003 land was acquired, Milord. Till
Junior
then
Government
nothing has
Advocate.
happened. They are not
Land
realizing
acquired,
how to the
land
extent of
acquired,
interest they
land acquired.
Yes,
Huh.
for national games, Milord.
Okay. You have not got money.
Neither money, initially there was an order for giving us equivalent land, that also they have not done.
Yes.
But they were, their interest
much
burden,
time-
they could realize.
P.K. Metil and Junior Government Advocate
Lordship,
appearing for the
permit
state
please.
respondents.
2 weeks.
As sought for.
2 weeks. That's it.
To file what?
2 years. Lordship.
Reply to the the
Amended.
amended writ petition.
Okay, okay. To file an affidavit in reply to the amended
Writ
writ petition. Okay. The request is accepted, raise the case on sides.
For 2 weeks. And my lord, item number 7, can I pray for my lord 2nd or 3rd of September, my lord? It's a small covered matter, my lord. It's a covered by division bench judgment of the Sikkim High Court, which has been affirmed by the Supreme Court. Dui batini.
And accommodation, Mr. Kane Churil and senior counsel, yesterday by so Arbora. Okay.
Ranu Bora.
That's for listing of the case on another date. Who is industry commerce? Anybody is available?
Government advocate. We'll inform me, lord.
Silo about it.
3rd, my lord.
We'll find out.
My lord, my lord. Deep breath.
Saipala did you go there? Where were we?
Lordships wanted to now see the notifications by which the education cess and higher education cess has been brought into. Lastly, we read the judgment, Lordship, of the impugned order and then the letter. So now Lordships wanted to appraise about the notification. So Lordships, in my compilation which I had handed over, Lordships,
Yes.
page number 7, Lordships, is the first section 91, Lordships, whereby education cess was introduced. Lordships, it's an extract of Finance Act number 2 Act of 2004, section 91. Without prejudice to the provisions of subsection 11 of section 2, there shall be levied and collected in accordance with the provisions of this chapter as surcharge for the purpose of union, a cess to be called as the education cess to fulfill the commitment of the government to provide and finance universalized quality basic education. Subsection 2, the central government may, after due appropriation made by the parliament by law in this behalf, utilize such sums of money of the education cess levied under subsection 11 of section 2 and this chapter for the purpose specified in subsection 1 as it may consider necessary. Next, Lordships, next page, section 92, that is in definition. Same Finance Number Act of 2004, Lordships. The words and expressions used in this chapter and defined in the Central Excise Act 1944, the Customs Act 1962, or Chapter 5 of the Finance Act 1994 shall have meanings respectively assigned to them in those acts or chapter as the case may be. Then, Lordship, section 93, excise education cess on excisable goods. Subsection 1. The education cess levied under section 91 in case of goods specified in the first schedule of Central Excise Tariff Act 1985, being goods manufactured or produced, shall be a duty of excise. This is really irrelevant, Lordships. Shall be a duty of excise in this section referred to as the education cess on excisable goods at the rate of 2% calculated on the aggregate of all duties of excise, including special duty of excise or any other duty of excise, but excluding education cess and secondary and higher education cess levied under section 136 of Finance Act 2007 on excisable goods, which are levied and collected by the central government in the Ministry of Finance Department of Revenue under the provisions of the Central Excise Act 1944 or under any law for the time being in force. So here, Lordships, important to note is this education cess shall be a duty of excise. Now I'll take the Lordships to the again the notification which exempts a claim, gives refunds of the duty of excise. I'll take your Lordships to that, but just let Lordships will complete subsection 2. The education cess on excisable goods shall be in addition to any other duties of excise chargeable on such goods under the Central Excise Act or any other law for the time being in force. The subsection 3. The provisions of Central Excise Act 1944 and the rules made thereunder, including those relating to refunds and exemptions and imposition of penalty, shall, as far as may be, apply in relation to the levy and collection of education cess on excisable goods as they apply in relation to levy and collection of duties of excise on such goods under Central Excise Act or rules. So, Lordships, when the legislature brought in this education cess, it made very categorically clear under section 93 that this education cess is a duty of excise, as well as all the provisions governing the levy, exemption, refund of excise duty shall mutatis mutandis apply to education cess also. White subsection 3. So this is on the chargeability, lordships. Now, lordships, this was clarified. There was a clarification given by the board, lordships, as to the operation of how this cess would operate. That lordships may kindly come to page 46 for once. In 2004, lordships, when this cess was introduced by Finance Act number 2 of 2004, the TRU, the tax research unit of the department, by this letter dated 10/8/2004, issues relating to imposition of education cess on excisable goods and on imported goods as pointed out by the trade and field formations regarding. The undersigned is directed to state that subsequent to budget 2004 announcements, a number of representation reference have been received from the trade as well as from the field formations pertaining to imposition of education cess on excisable goods and on imported goods. The points raised and clarification thereon are as follows. Issue number 1. Whether education cess on excisable goods is leviable on goods manufactured prior to imposition of cess but clear after imposition. That is not relevant for our purpose, lordships. I am skipping. Issue number 2. Whether goods that are fully exempt from excise duty, customs duty, or are cleared without payment of excise duty, customs duty, such as clearance under bond or fulfillment of certain conditions, would be subjected to cess. Clarification. The education cess is leviable at the rate of 2% of the aggregate of all duties of excise customs, excluding certain duties of customs like anti-dumping duty, safeguard duty, etc., levied and collected. If the goods are fully exempted from excise duty or customs duty, are chargeable to nil rate of duty, or are cleared without payment of duty under specified procedure such as clearance under bond, there is no collection of duty. Thus, no education cess would be leviable on such clearances. In this regard, letter DO dated this issued by member may also be referred. So it clarifies that if duty is nil, because cess is calculated on as a percentage of duty. If duty is nil, then cess is also nil. Or duty is exempted, then cess is exempt. Issue number 3. Whether goods like alcoholic beverages that do not fall under central excise tariff be subjected to levy of cess on excisable goods as part of CVD when they are imported, or that's not relevant for our purpose because we are into excise goods. Issue number 4. Whether duty cesses which either not collected as duty of excise customs or are collected so but by a department other than Department of Revenue should be included for the purpose of calculation of education cess. Clarification. As education cess is calculated on the aggregate duty of excise to customs, excluding certain duties of customs like anti-dumping duty, safeguard duty, etc., levied and collected by the Department of Revenue, only such duties which are A, levied and collected as duties of excise customs, and B, are both levied and collected by Department of Revenue should be taken into account for calculating education cess. So, lordship, in the facts of the present case, excise duty is the only duty levied and collected by the Department of Revenue. Therefore, education cess follows the excise duty in the facts of present case before your lords. So, lordship, this circular and the entry section 93 of Finance Act number 2004, which is at lordship's page number 9. So when we read 9 and 46 together, lordships, what transpires is that education cess is a duty of excise, and the governing provisions of the Central Excise Statute as regards to refunds, exemptions, levy is governing the levy of education cess also in all circumstances. Lordship, under this background now, lordships, may I take your lordships to the notifications
Yes.
Lordship, may kindly take the first notification at page 19 of the compilation. May I please, Lordship?
Yes.
Notification 20/2007. In exercise of powers conferred by subsection 1 of section 5A of the Central Excise Act 1944, the central government being satisfied that it is in public interest to so to do, hereby exempts the goods specified in the first schedule of the Central Excise Tariff Act 1985, other than those mentioned in the annexure, and cleared from a unit located in states of Assam or Tripura or Meghalaya or Mizoram, Manipur, Nagaland, or Arunachal Pradesh or Sikkim, as the case may be, from so much of the duty of excise leviable thereon under the said act as is equivalent to the amount of duty paid by the manufacturer of goods other than the amount of duty paid by utilization of Senvet credit under the Senvet credit rules 2004. I stop here for a time. Because if this notification says, as the case may be, from so much of duty of excise. Now, Lordships, if this is read along with section 93 at page number 9, Lordships, education cess levied under section 91 in the case of goods specified in first schedule to Central Excise Tariff 1985, being goods manufactured or produced, shall be a duty of excise. So,
Yes.
Lordships. So, Lordships, under this background, under the facts of the present case, I was, and my eligibility was disputed by the department since 2010. In the list of days, Lordships, 2010, the order in original 21/4/2010 was passed, wherein my eligibility was upheld, which was challenged by the revenue up to 2023, Lordships, when the division bench of our Honorable High Court passed the order on 25/10/24 upholding my eligibility. So all these years, there was no dispute as to my eligibility for the claim of refund of education cess also. I, during this period, had claimed self-credit only of basic excise duty. It is not in dispute, Lordships, that I had from the beginning claimed cess also. That is not a point of dispute at all. After SRD nutrient judgment came, I applied with all the details before the proper officer, because SRD declared that cess credit is also available. Refund or exemption is allowed to education cess and higher education cess. So the moot question which falls for your lords to decide would be whether my claim of refund of cess had crystallized prior to the unicorn judgment or not. A revenue department litigating my eligibility for around 14 years, and once they lose, they take up another stand to deny me a refund which has already crystallized much before the unicorn judgment had come into place. Next, lordships, the CBIC circular which clarified the trade as well as field formations doubt at page 46. That also, lordships, categorically stated that education cess being a duty of excise, all the exemptions, refunds, processes as per the duty of excise duty will be applicable to this also. Now, in the facts of the present case, lordships, the commissioner drops 23 show cause notices. Commissioner White OIO number 2 dated 29/1/25 dropped protective show cause notices 23 number. Now a subordinate officer of the commissioner in the rank of assistant commissioner is sitting on the judgment of the commissioner, order of the commissioner, by denying the education cess to me when there was no dispute as to my claim of education cess. Since the beginning, I had filed the application for basic excise duty. After that, after SRD, I filed the application for cess and higher cess. Commissioner, while dropping the 23 protective show cause notices and fixing the special rate, after these two events have happened, then can a subordinate officer sit on the judgment of the commissioner, order of the commissioner, fixing special rate and dropping the 23 proceedings by giving reference to a judgment which was not in existence when my claim was filed? So in this regard, lordships, I would like to place couple of
What is the subsequent judgment?
Unicorn Industries, lordships.
Who is that?
Lordship, Unicorn Industries, lordship, is that page number 70. SRD, lordships, is that 47. Review petition against SRD was also dismissed in 2010, lordships, which is at page 68. Decided on 10th of July 2018, lordships, review petition at page 68. It was dismissed. So SRD was holding the forte till that time, lordships. The review got dismissed, and then Unicorn came, lordship, on December 6, 2019. Lordship, the reliance in Unicorn of Modi Rubber was regarding NCCD, which was a special levy. Education says section 93, which your lordship has seen, had specifically provided that it's the duty of excise for NCCD at that moment of time when Modi Rubber was pronounced, there was no such specific provisions. And therefore, the court interpreted the exemption being limited to a duty of excise. But when in case of education says and higher education says, when the statute itself says it is to be a duty of excise and to be governed as per the provisions of the Central Excise Duty and Central Excise Act 1944, then denying me exemption and allowing me refund of only basic and not allowing me the refund of cess on the ground of unicorn, had my claim for cess come arisen after unicorn judgment, lordships, I would have not come before your lords. But my facts of my case, lordships, the claim crystallized before that.
After this,
Unicorn.
your claim for refund was returned.
Lordship, returned. That means it was.
Just a
Lordship. So I apologize. I will first ask.
You do not allow me to complete
No.
the sentence.
Lordship, I apologize. I apologize.
Did you agitate this issue at any point of time prior to this writ petition?
Lordship, this return of the refund.
Whatever return, it
Return.
says return.
It says return. Lordships.
Did the petitioner agitate it? Did the petitioner agitate this
No,
issue?
Lordships. The petitioner, because was pursuing the, as per the statement given in the letter, Lordship, that an appeal is filed and it is pending before the tribunal. The petitioner was pursuing that appeal before the tribunal.
Because that was regarding eligibility.
Eligibility, Lordships.
It was completely silent about this says.
It was silent. It was
Right.
Lordships.
So did you agitate this issue anywhere since 2019?
No, Lordships. No,
No.
Lordships. I did not agitate it because of the reasoning given in the letter that because their eligibility is doubtful.
Because by that time, both the judgments have came.
Yes, Lordship. By that time, both judgments have come.
Both judgments have came.
Lordships.
So that is what I am asking.
I did not
So-
agitate, Lordship. It's a fact. I cannot improve on my facts, Lordship. It's a fact.
So you preferred this writ petition when?
I preferred this writ petition when my
2020.
claim of cess came to be rejected. By this impugned order, Lordships, on 11/2/25, my claim of cess came to be rejected without issuing any show cause to me. Lordship, how did the events, if I may place before your lords,
Just a minute.
Lordships?
After this were returned, then what did you do? File another application or what? This order came page 95.
95 is the subject
How-
matter.
Huh?
Is the subject matter of challenge before your lords.
Right. How did it originate?
It originated, Lordships.
Where is that originate?
Lordship, it is recorded, Lordships.
Which?
Lordship, para number 4 onwards, may I please? Page 96. Para 4, 5 onwards. Lordship.
No, you renewed this prayer, para 2.
Para 2 of the prayer of the writ, Lordships.
No, page 96.
Page 96, para 2. The
Is it
same
not?
SSE, white their letter dated 23/1/25 has submitted refund application of Central Excise Duty on special rate fixed for the value addition on the strength of Commissioner's order dated 21/1/25 in terms of notification 20 as amended from 9/10 to 14/15.
I think this is.
Yes, Lordships.
Then you come to para. All these are next story
Lordship.
regarding fixing of
Special rate,
spatial rate.
Lordship.
Then para 9 perhaps.
Lordships,
right?
Lordships.
So this is the story.
The-
Sequence.
Sequence, Lordship. I'll just take 1 minute, Lordships.
First, that which is not part that it was returned.
That
Which,
was in
huh,
between, Lordships.
in 19,
19,
2019.
December, November 19.
19.
Now-
So after fixation of the special rate, you filed this application on 23rd of January 2025.
So, Lordship, before fixation of special rate, our division bench order, that was the final point. 25, 10, 24.
No, that is regarding eligibility.
So that was
The
the
issue was settled by that.
Lordship. So
Thereafter, special rate.
thereafter, first Lordship dropping off all the protective demands,
Thereafter, special.
then special rate, and then
Right.
this refund order.
Right.
This is the sequence. Lordship,
And in your list of dates, is it the sequence mentioned?
Lordships, that is what I was trying to show.
That is that this 23/1/2025 finds reflection there.
Which one, Lordship?
That your refund application dated 23/1/2025.
No, Lordship,
That needs to be.
it takes reference of Lordship, the orders actually.
No. This needs to be because that has been decided, but because the lease started from 2010,
Lordships,
right?
Lordships,
And it reached up to 2025.
Lordships,
Because in this maze of dates,
Lordships,
I'll be lost.
Lordships.
If you don't,
I will prepare another one, Lordships.
if you don't give it sequentially,
Lordships.
the impugn order came to be passed in a refund application filed in 2025, 23rd January.
Lordships.
This impugn order,
Lordships.
whether that is mentioned here,
No, Lordship, that is not mentioned. I have after the division.
because
Lordships.
otherwise that will be the.
No, Lordship, I will file 2-pager only list of dates separately, Lordships. I'll prepare and file.
Because that is the starting point for this impugn order.
Lordships. There's one
Others
are there.
are also there,
Lordships.
related, but
For
impugn
this-
order came to be passed in the refund application dated 23/1/2025.
Lordship, but just one point, just to add, Lordships, 23/1/25, I may not say it to be a refund application fresh. It was a communication letter.
Show us.
Lordship, that letter is not on record. I will place that. I place a list of dates with that letter. No, that's because that is not a disputed fact here, Lordships. But my
No,
point,
not the dispute. I'm
No.
not saying that.
no, not dispute. Factually, it is factually what that's fallen from your lords. I cannot improve on that. But my just one point here, lords, that they have paid me interest. Had this been a case,
No, interest on what?
interest on this special rate difference amount, Lordship, kindly takes this order, I'll place that. They have computed the interest. After this, Lordships, para number 106, page 106, para 33. This is relevant, Lordships.
In a repetition.
In the writ petition, Lordships.
But that is excise, basic excise.
Basic excise. Basic excise.
Interest on basic excise.
Basic excise. But what has been recorded in the order that I'll just show before you. For this part of the order, we had not come, Lordship. We had been there till the cess part. Lordship, page 106. Para 33 onwards. May I please, Lordships?
But if you say, if your refund claim on cess and educational cess is allowed, interest will be allowed.
Interest will be allowed, Lordships. If it is held to be crystallized in the pre-unicorn era, then interest will automatically flow because two type of claim is there, Lordships.
Because there are three sets of judgment, I think.
Lordships.
One is first in point of time, they say, unicorn say, Modi rubber and one more. something.
Lordships.
Then came SRD and one more.
Yes, SRD and Bajaj,
something.
something.
Then came
Unicorn.
unicorn.
Then-
And one more, I think.
Unicorn.
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 So there are 3 layers of judgments.
Yes, one is pre-19, after, pre in 1971.
The exemption is different.
Yes,
but chase and education in chase or higher education chase came about later on,
Later,
2004 and all.
Lordships.
That is one that how this chase came about.
Lordships.
There is one more that principle involved,
Lordships. Jurisprudence.
jurisprudence.
Lordships.
So this is one is
I
jurisprudence.
agree what has been falling from your laws.
And one is presence of some statutory provision regarding this chase, education in chase, all this higher education chase.
with specific provision of how to govern them, which
Ah.
may be
For
absent.
that, for that, I have to read all the three,
Lordships, I am just,
all the 3 states of
Lord-
judgment
Lords,
minutely to understand the principle.
I will just
That
place
is one, but otherwise statute, that is statute,
is in my favor.
it stands
Lordships.
where it is.
It stands with
Thus, it
Let-
is a judgment and principles which varies.
Lordships. That is the crux. What I summarize, what your Lordship has summarized, that is the crux.
Statute chase, it stands since 2000, Finance Act 2004
Lordships.
chase. Or higher education chase
Seven.
under section 93, it stands.
It stands.
Now, question is about its applicability or non-applicability.
In the facts of the present case.
Facts of the case
Because-
plus the ratio or principles laid down in those 3 states.
Three
of
sets
the-
of judgments. But Lordship, after these 3 sets of judgment, there has been judgments by coordinate bench and division bench of our court and Supreme Court finally in Saraswati Agro, wherein it was held that one cannot open a Pandora's box if all the assessments which was prevailing till the time as unicorn was not pronounced, means 5th of December 2019, all those assessments which are finalized are crystallized. You cannot reopen them on the garb of unicorn. I'll just try to place those 3 judgments. I'll not place these SRD unicorn Lordships has seen, but these 2-3 line of judgments in my written notes also, I have just highlighted the crux of them, Lordships, and the detailed judgment copies are on record.
Let us have the detail.
Detail. The first is Lordship. First, I'll take Lordship to Supreme Court Saraswati Agro, which is at Lordship's page number 155 of the compilation.
Page
155 Lordships. Commissioner of
is it reported in SSC?
I will find
Because
out.
I find it very
I will find out, Lordship. I mostly 100%.
inconvenient.
No, it will be reported, Lordships. It is not
Saraswati.
because it was a important ruling. I believe 100. I will give that citation also, Lordships. It starts at page 156, Lordships.
Yes.
May I please, Lordships? Delay Kondo, we have heard Mr. N. Venkataraman, learned ASG, appearing for the petitioners in extension. He pointed out that this court, in case of SRD Nutrients Private Limited versus CCE reported in this, gave a ruling contrary to the judgment previously rendered by a 3-judge bench of this court in Modi Rubber and Union versus Union of India and others reported in this. In a subsequent decision, namely Messrs. Unicorn Industries versus Union of India reported in this, the judgment passed in SRD was overruled and it was held that exemption from payment of excise duty under a notification granted would not exempt the payment of cess and higher cess. It was also observed in the said judgment that the judgment passed in SRD was per inquiry. 3. Learned ASG during the course of his submission has brought to our attention an order passed on 27/9/21, referring the very decision passed in Messrs. SRD, which has been overruled to a larger bench, having regard to the fact that the state decision was per inquirium inasmuch as it had not considered the earlier judgment of the court in Modi Rubber Supra. Therefore, he submitted that this matter has to be connected with the said matter and the judgment to be passed in line with Messrs. Unicorn in Messrs. SRD Nutrients Limited when the reference is answered would follow in this case also. We have given our anxious consideration to the submissions made by the learned ASG in light of what has been stated by the High Court in para 74 of the impugned judgment. In SRD Nutrients, it was held that when payment of excise duty is exempt under Central Excise Act, then 2% education cess and secondary and higher education cess payable on the aggregate duty of excise will also be exempted. However, later in the case of Messrs. Unicorn Industries versus Union of India, the aforesaid judgment in SRD was overruled and it was held that although the exemption from payment of excise duty under a notification is granted, there is no exemption from payment of education cess. Therefore, the SSE who had paid excise duty and education cess was not entitled to refund of education cess, which has been paid. Also, where refund has been made pursuant to the judgment of Messrs. SRD was no longer valid. With regard to the reference order made on 27/9/21 on a miscellaneous application filed by Revenue seeking to undo the judgment of Messrs. SRD, which was overruled in subsequent judgment of this court in Messrs. Unicorn Supra, the question is whether there was a need at all to refer the matter to a larger bench. This is for two reasons. Firstly, such an application could not have been filed after a review petition of SRD had been dismissed by this court. Thus, in substance, by filing the miscellaneous application, the Revenue was seeking a second review of the said judgment, which is impermissible in law. Secondly, by ignoring the explanation to order this of the CPC and the principle that emerges from the same, what is sought to be contended by the learned ASG is that if a judgment is overruled by the court, by this court, by a subsequent judgment, then the overruled judgment will have to be reopened, and on reopening of the said judgment will have to be brought in line with the subsequent judgment which had overruled it. This is not permissible in law for two reasons. Firstly, there has to be a finality in litigation, and that it is in the interest of state. Secondly, a person cannot be vexed twice. This is epitomized by the following maxims. Nemo det. These three maxims I am skipping. I am going to the next. These maxims would indicate that there must be an end-to-end litigation, otherwise rights of person would be in an endless confusion and fluid, and justice would suffer. That is why explanation to order this rule 1, which is a wholesome provision, has been inserted to the Code of Civil Procedure. It states that once there is a subsequent judgment overruling an earlier judgment on a point of law, the earlier judgment cannot be reopened or reviewed on the basis of subsequent judgment. The contention of the Revenue is that in view of the subsequent judgment of this court in Messrs. Unicorn Industries, recoveries could be made from SSEs with regard to refund of cess made by the department, or if not paid by the SSEs following the judgment of in SRD. In the above circumstances, appeals were filed before the High Court by the SSE. In the instant case, the High Court had raised the following question of law and answered it against the Revenue: whether the SSE is liable to return education cess and higher education cess on the changed view of law as subsequently laid by the full bench of Supreme Court in Unicorn, overruling SRD, on the basis of which aforesaid cess was refunded to the SSE. In our view, the High Court has rightly answered the question. The High Court, in the impugned order, while considering the judgment passed by the court in SRD as well as Unicorn, has observed in para 74 as under. Applying the aforesaid principle in the case at hand, since the SSE had been held entitled to the refund of the education cess on the basis of a judgment and order of Supreme Court in case of SRD, which was in vogue at the relevant time, the appellant are not entitled to make recovery of the said refunded amount on the basis of the subsequent decision of Supreme Court rendered in view of the Unicorn Industries. If such an action is permitted, it will open a Pandora box, and the list between the parties which had attained finality will never come to an end. This would be against the public policy which envisages providing quietus to litigation at some stage. In substance, the High Court has stated that the decision in SRD had attained finality and was binding on parties thereto. Therefore, the subsequent decision of this court overruling SRD in case of Unicorn Industries cannot have a bearing on past decision which had attained finality, although they had followed SRD, which was subsequently over by Unicorn. Otherwise, a Pandora's box would be open. This is exactly what was sought to be done by order. When we read the reference order in light of that, we find the reference was unnecessary. In such appeals are dismissed. Now, Lordships, in the facts of the present case before your Lords, my application for refund of cess on the self-credit was with them in November 2019. They have not rejected my application. They returned my application, Lordships, on the ground that your eligibility is pending. Now that eligibility decided in my favor by the tribunal at that moment and then by the division bench of our Honorable High Court. Now the question is, Lordships, subsequent after the division of bench order, Lordship, judgment, Lordships, the department processes my claims. It drops 23 protective show cause notices, it fixes special rate, and it processes my claim of excise duty along with interest. Therein, can a subsequent judgment of the Supreme Court negate my crystallized refund claim of cess and higher cess, which was returned to by them on the ground of eligibility being paid? This similarly, Lordships, our division bench in Union of India versus Kesari Industries 2021, Lordships, that is at page number.
So far, your case,
Lordship.
this, which one? This Soros Road. Soros Road is page 155.
155, Lordships.
Down to para 9.
The
It
contention.
was argued by revenue that in view of the subsequent judgment in Unicorn, they could make recovery from the SSC.
Lordship.
Those who were already refunded.
Already,
This is one category,
Lordships. But
right?
Lordships.
The purpose of filing this, because revenue was the appellant.
Revenue was the appellant, Lordships.
One,
High Court allowed petitioners and revenue went to appeal.
they say so that they can recover from the SOC with regard to a refund of education cess made by the department. This is one.
Lordships.
And if second, if not paid by the SSC, following the judgment in SRD,
Lordships.
right?
Lordships.
These are the two categories.
One is, Lordships,
That is the purpose for filing this appeal, Saraswati,
by the revenue.
by the revenue.
Lordships.
Now your question is whether your case has been crystallized.
Lordships.
First,
Lordships.
because they have already recovered the amount from you.
They have,
They have not refunded the amount.
Lordship, they have not refunded. I have paid to them, they have not.
You have paid, they have not refunded.
Lordships. They have not.
So neither of these two categories, to neither of these two categories you belong.
Lordships, I don't belong because
Right.
my
Your case is different.
my case, why
The
I rely
facts-
on this?
No, the facts are now
Similar.
clear. No,
Yes,
facts are clear.
Lordships.
Every case is different.
Different. Every case will have its own factors.
But you do not fall into these categories that
My case is
that
not,
you have been refunded the amount,
not that.
they want to recover it. No, that is
No.
not the case.
But why I
And
rely,
after second one,
Lordships.
no, we have read the judgment together,
Yes, Lordship. I am following what your Lordships is asking me.
right?
I am not falling in these two categories.
That is what I have
Lordship.
said only. I have not said about your
No,
right or
No, Lordships.
no right. Because the purpose behind this appeal are two, according to the learned ASG
Lorships,
before the
before the
Supreme
Supreme
Court.
Court.
One, and they negated firstly that second review is not possible, and by the explanation to order 47, rule 1,
Rule
subsequent judgment.
will hold prospectively, not retrospectively. That is a settled issue. Why I wanted to rely on these Lorships was if this honorable court holds that my claim, what has fallen from your lords, that crystallization of my claim.
Yes, yes, we'll look into that.
Lorships. And Lordship, then similarly, our division bench in Union of India versus Keshri Industries, Lordships, that is at page number 197. There are actually, the cost title is very big, Lordship. It starts at the operative part of the judgment starts from page number 223.
Tell me what are the facts?
Facts is, Lordship, here also recovery.
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 So first category.
First category. First. I'll just place, Lordships. Lordship, just may Lordships may kindly take para 33, last page 250.
So no recovery perhaps?
In my case,
No. In this batch of case.
no recovery.
No, let's see if this is not referred by me. Let's see what happened after Unicorn judgment was passed. We issued notice to the industries, SCC, that we have to refund the amount.
I like Saraswati.
Yes, Lord. That is covered by Saraswati.
Saraswati.
Yes, Lord. Thereafter, we have not proceeded.
Saraswati is referred to here. Oh, sorry, it's not Saraswati.
Saraswati was after this, Lordship.
After this. So it is ahead of it.
That's
It
the
is
end
ahead,
of it.
it is ahead of
It
it.
is. Here, Lordship, it was decided that once
Once
refund is-
it happened on a point when I was very newly elevated. I passed an order, long order. After declaring signing, then at night I see that next day I signed the order. Next day on the same point, Supreme Court has passed the order, passed an order. I was a bit worried till I could see the judgments.
Supreme Court.
Headline is okay.
But the
On the
context of the
same
judgment.
point. And the next day I saw that my judgment is one day ahead of the Supreme Court judgment.
That's it.
Exactly, almost ditto. Anyway,
So, Lordship,
para 33.
para 30. To summarize, the basic argument of respondents would be that irrespective of the fact that Messrs. SRD Nutrient has been declared as per inquirium, the matter has attained finality between the parties inasmuch as the order passed by the revenue for refund of the amount has not been challenged, nor has the order of the learned single judge by which the learned single judge has directed that in view of the SRD, the amount should be refunded. Been
What is
taken
the
in,
date of this judgment?
Lordship, that is Topcam Limited, Lordships. This
Kesri.
Kesri Lordship. Kesri Lordships dated.
Date is missing.
Lordship, it is delivered on 8th October 2020.
Where is it?
It is at page 197, top right hand side.
197.
Neutral
Seven.
citation is also given, Lordship.
Okay.
8th
Okay.
October 2020. Could be 1 or 2.
Could be 21.
21, Lordship, because the neutral citation is of 21 only.
Could be 21.
21.
8.
October
10.
2020.
So Saraswati came much later.
Much later. From Jammu, it carried from Jammu Kashmir, I call it.
Yes, para 33.
But to
What do you want to
summarize,
show?
the basic argument of the respondent would be that irrespective of the fact that Messrs. SRD Nutrients has been declared as law, has been declared as per inquirium, the matter has attained finality between the parties inasmuch as the order passed by the revenue for refund of the amount has not been challenged, nor has the order of the learned single judge, by which the learned single judge has directed that in view of the SRD, the amount should be refunded, be taken in writ appeal before this High Court. The matter having attained finality, it cannot now be opened at this stage, even though Messrs. SRD has been declared as per inquirium in case of Messrs. Unicorn. We agree with the submission of the learned counsel for the SSC that the facts and circumstances, the amount refunded to them cannot be recovered. So it was a case of recovery, Lordship, which subsequently Supreme Court has also upheld. So, Lordship, in my case, Lordship, if I, Lordship, may I just take my written notes, I'll just conclude now, Lordship. I'll hand over the fresh list of days, Lordships, by tomorrow, Lordship. Lordship, first in submissions, page number 2, eligibility and special rate having attained finality, the said denial is inconsistent. Why I say so, Lordship? Because the cess claim was lodged when SRD held the fort. That is my reasoning given. That is my justification when I say the cess claim is, the rejection of cess is unilateral by the law. Next, Lordships, page number 4.
That is which that loose sheets you have given.
Lordships, the 3 pages.
3 page you have given.
Yeah, Lordships, Lordships.
Somewhere.
Letter dated 17/12/19 of the revenue and my application 20.
Your application 22nd November
November
2019.
Lordships. In my written notes, I have taken reference to that. Then page number 4, Unicorn does not permit reopening or denial of position settled under SRD. This is important. Reopening also not permitted or denial of position. So my case, what I'm trying to make out before your lords is that crystallization happened in pre-Unicorn era. So therefore, the Unicorn is not available to them as a defense to deny me this cess claim. And last, Lordship, which I will not press, my page number 5, Roman 4, is regarding, Lordships, the judicial discipline by respondent number 2 has passed the impugned order. On the ground, Lordship, the Commissioner's OIO dated 29/1/25 dropping all 23 show cause and the special rate order dated 21/25 are quasi-judicial order which stand unchallenged. Nobody has challenged those. The revenue is not in appeal in any fora. In refusing the cess refund, the Assistant Commissioner has in fact sat in appeal over the orders of his own superiority, which is impermissible. Which maybe, Lordship,
we'll look into it.
which academically, Lordship, maybe not. Because I was preparing it, it was a part of my application, therefore I bring into this. So, and finally, Lordship, page number 6, cess refund was rejected without any notice to me. There was no notice of rejection. Just by this order, it stands rejected. And therefore, the relief, Lordship, is that my relief is set aside the OIO to the extent it rejects cess and a direction to respondent 2 to press and disburse the differential cess computed on special rates fixed by order dated together with interest within a time frame as this. Grateful to you, Lords. Always a pleasure to argue.
Lots.
On the law, okay, but facts, if you are.
Well, I will be very short because my learned friend has placed the relevant judgments and all those things. I will not burden your lordship with the policy notifications and all those. Your lordship has seen. Your lordship has seen the judgment up to the special rate. There is no dispute. Your lordship has seen SRD. Your lordship has seen Unicorn, and your lordship has also seen the SRD, Sorcery. Now, as your lordship said, observe that in SRD, 2 issues were there. One,
For are good, revenue are good.
Well, argument and ultimately, well, what ultimately I decided, I will come to that, that the amount which has already been refunded, whether that can be recovered or not. Secondly, the amount which has not been paid by the assessees, whether that can be directly paid. And thirdly, which is there in the finding of the Supreme Court, that the matters which have attained finality, they cannot be reopened. In fact, these are the three issues. In the division bench judgment of this Honorable Court, also in see para 33, it says the refund orders have become final as no appeal was preferred against the refund orders. Now, I will take give your lordship the summary, I'm not burdening your lordship unnecessarily. In my case, what has happened, refund orders were passed. For 5 periods, the refund orders were passed. Now, after passing of the refund orders, certain payments were also made and certain payments were not made.
Not released.
Not released. A part of the payment was made and part of the payment was not released. Subsequently, a 11A notice was issued for recovery of the amount. Now, after the final order which was passed, the authority has said,
We have a list of dates.
I'll give everything I will give. I'm just giving a preface only. The revenue has said that so far as the amount which has not been disbursed, that has been appropriated, and thereby 11A notice in respect of that amount is dropped.
What is 11A notice?
Well, for reopening whether erroneously refunded.
Okay.
So they say the amount which has not been disbursed has been appropriated by the revenue, and thereby 11A proceeding in respect of that amount is dropped. In respect of the amount which has been released, they have confirmed the demand and directed the assessee to pay the amount with interest. These are the two issues. List of dates, my lord, I've given. Now, before I take your lordship to the factual part, my lord, there is no dispute on this aspect of the matter. I will take your lordship to the entire thing, my lord. Now, my submission before lordship is twofold. One, the amount which has already been disbursed cannot be recovered by virtue of the judgment of the apex court, as well as the division bench judgment, the single bench judgment, the Tripura High Court judgment, the Meghalaya High Court judgment. I place before lordship. My lord, it cannot be recovered.
Multiplicity is not required. Kesari
Not-
is there and Saraswati is there.
My lord, not multiplicity. The reason was that, my lord, the lordship 6 into 11A. If your lordship looks into 11A, then lordship may find policy
Of
of the Central Excise Act. Mary, no? Where any duty of excise has not been levied or paid, or has been short levied, or short paid, or erroneously refunded for any region other than the region of fraud, so and so. So, lordship find one is that the duty of excise has not been levied. Now, in our case, this is not a case at all because we have already paid. Levied or paid, or has been short levied or short paid. Up to that, it is not applicable. Or erroneously refunded. Now, lordship I will take a lordship to the judgment of this honorable court also directly on the issue. That when the refunds were sanctioned and paid, they were not erroneous because they were on the basis of the existing law. And when some action has been taken on the basis of an existing law, then on the basis of the subsequent judgment, the earlier action cannot be said to be erroneous. There is a division bench judgment of this honorable court on this issue in Victor Kane. I'll place it before Lordship directly on the same issue. Now, this 11A speaks of only recovery. Lordship, kindly see, it speaks of only recovery of the amount. Now, in my case, the amount which have already been refunded, they will not fall within the purview of erroneously refunded. And following the judgments of this honorable court, as well as the apex court, the amount cannot be recovered. Now, the amount which had not been refunded, they are on the basis of the refund orders already passed. And against that orders, no appeal was preferred. They have attained finality. Once the refund orders have attained finality, 11A does not empower the authorities to initiate any proceedings against those orders. Now, they say, authority says that since it has been appropriated, the proceedings are dropped. That means 11A proceeding is not there. That proceeding has been dropped in respect of the amount which has not been refunded. If those proceedings are dropped, then is after the order of the refund which has attained finality, how that amount can be appropriated by the department? On what basis? My lord, amount can be appropriated by way of either it appeal or by direction of the higher authority or someone. The refund orders are final. And you have not filed appeal that have attained finality. There is no power to appropriate that refund amount on the basis of a judgment of the Supreme Court subsequently given when those refund orders were passed on the basis of the SRD neutricals. Now, if you lordship once again for the repetition also pair 33 of that judgment, my lord, of this honorable court judgment, my lord. 164 compilation, my lord, my compilation.
You want which one? Kesari?
No, my lord, Kesari, my lord.
Okay. Which paragraph?
Para 33. To summarize, the basic arguments of the respondents would be that irrespective of the fact SRD neutricals has been declared per inquirium, the matter has attained finality between the parties in as much as the order passed by the revenue for refund of the amount has not been challenged. Nor has the order of the learned single judge by which the learned single judge has directed that in view of SRD neutricals, amount should be refunded has been taken in the writ appeal before this court. Meaning thereby, my lord,
Yes.
the amount which has been refunded, you cannot recover in view of the judgment of this honorable court as was followed by the Saraswati judgment of the Supreme. In respect of the amount which had not been disbursed, but the refund orders were passed and which were not challenged, that is squarely covered by the division bench judgment of this honorable court, that the refund orders which were passed and which were not challenged and have attained finality, the disbursement will have to be made. Now, my case falls in the two categories only. One, some amount refunds were granted, and certain amounts refunds have not been granted, but the department says since it has been appropriated and thereby 11A proceedings have been dropped. Now, the submission for lordship is that 11A is only for recovery.
In the present case, the question of recovery does not arise because both the amounts were paid. One has been refunded partly and another not refunded. So there is no question of application of 11A. And once the authority has dropped the 11A proceedings in respect of those amounts, there is no proceeding pending against the refund orders which had attained finality, and therefore those amounts are also liable to be refunded to me along with the interest. This is the short, my lord, if I may say, the petition is so bulky, but this is the short, the summary. If your lordship looks into the below this, my summary. One more. My lord, the first page is about the industrial policy, excise notification. I may not take your lordship because it has already been placed before your lordship, my lord. Then the establishment of the petitioner industrial unit, that is also factual because there is no dispute in my case about the eligibility and all other issues, my lord. Curtailment of the benefit, that also I'm not placing because that was also placed by your lordship, my lord, where it was reduced to 56% value addition, and my lord, the judgment was passed by the Supreme Court. Now, thereafter, lordship, see proceedings before the Supreme Court, that also, my lord, has been placed before lordship, my lord. VVF judgment, I think it has been placed. My learned friend has placed before lordship the VVF judgment, whereby the division bench judgment of this honorable court was reversed. And
BVF
it was
is not placed.
not placed, we placed.
My lord, it was,
I will. Well, what happened, my lord? When the exemption was reduced to value addition, like 56% or whatever in the chart it was there, the notification was placed. That was challenged before this honorable court. And the learned single judge also allowed the petition and held that 100% below exemption will have to be allowed. The division bench also, my lord, confirmed it by holding that 100% exemption will have to be allowed. Appeals were filed before the Supreme Court against this judgment as well as the other judgments of the different high courts. And the apex court upheld the notification and reversed the judgment of this honorable court, meaning thereby the notification which was there, which provided for exemption on the value addition, was upheld
And as per the chart.
as per the chart.
And plus all other.
Special,
There are special.
special rate. So in our case, that dispute is not there, but we have given the history, my lord, that VVF judgment is there, that also is given in compilation.
So
But
for the other case also, there is no dispute about
so, my
that.
lord, I'm just given the history, my lord, only since it is not relevant for our
Yes.
case, that's why I'm not placing burdening your lordship, my lord.
Yes.
Now, thereafter, you also find VVF judgment. Thereafter, the education says and the secondary education says the imposition by the notifications, my lord, that I've been given, my lord. Then Supreme Court judgment and SRD articles, my lord. Has your lordship got it, my lord?
Yes.
That also in the compilation it has been given. Then refund orders were passed in 2015. You also may see the date. Refund orders also sanctioned, right? You also may see first is the unit, then period, then the claimed amount, and the sanction amount. The sanction amount was less because they applied the 56% or whatever the percentage was there on the basis of the VVF judgment. And as such, we claimed 100%, but it has been reduced.
So your claim is to the figure which is mentioned as sanctioned.
My lord, my lord, my lord. Now, these were all sanctioned, my lord.
Hmm.
And the refund orders, you'll also find the refund orders at the bottom, my lord. The refund orders sanctioning the amounts were passed as follows. You'll also see kindly, my lord.
Yes.
The different dates are there and all
Yes.
are annexed. If you also wants to look into it, I can place it. Otherwise, my lord, there is no dispute about it, my lord. These are
And
different.
all are prior to
19, my lord.
Unicorn.
My lord. Prior to-
Unicorn is in December 2019.
My lord. Now thereafter, the correspondences regarding the refund of the amount that we always made prayer that refund amount may be granted. Your lordship may skip over and may come to my lord the next so-called notice.
Okay.
So-called notices issued by the department under 711A. You'll also may see there are 4 or 5 so-called notices. Now the reply was submitted and ultimately you'll also find adjudication order, impugned adjudication order, my lord.
Yes.
Lordship got it, my lord. The assistant commissioner, respond number 3, wide or dated so-and-so received by the petitioner on so-and-so, in the said order, respondent specifically noted the judgment of the Topsam India and Kesari Industries and also acknowledged that the board had decided not to file an SLP against the Kesari Industries and yet proceeded to decide contrary these of the binding precedents with not following the judicial discipline. My lord, the authority has noted that there is judgment of this honorable court by learned single judge in Topsam and Kesari Industries, and that the board has decided not to file an appeal against the said judgment. In spite of that, my lord, the impugned orders have been passed. Now, your lordship may kindly see, my lord. 1, my lord, the order in original dated so-and-so, Unit 3, March so-and-so to so-and-so, rupees 68 lakh something, wide order dated so-and-so, it was sanctioned, my lord.
Yes.
Then, my lord, so-called notice is dated. Then you also find last refund confirmed, rupees 68 lakhs with so-and-so, penalty not imposed. So this amount which was disbursed, they have confirmed the demand and interest was levied, but penalty has not been levied. Similarly, my lord, in other cases also there, I will take your lordship to the chart, my lord.
First one is 68 lakh 83,045.
My lord,
That was refund sanction.
my lord,
Then a so-called notice was issued for under 11A.
my lord.
Then what is the operative part? Demand confirm means that they want
Return back,
one refund
my
or
lord,
recovery.
recovery.
Okay.
I will take your lordship to directly one chart where all these refund orders have been, my lord, summarized. That is page number. At page
11.
11, my lord.
Yes.
You'll also see the first so-and-so, the amount has been mentioned. Demand dropped. Disbursement denied. Money retained with the revenue. So this amount was not disbursed. So 11A proceeding in respect of this amount has been dropped. Amount has been retained by the revenue. Now in second case, you'll also see the amount is 9 crore 53 lakhs 41215 million. Demand confirmed on recovery disbursed amount. Demand did not but retained. So about 9 crore something demand has been confirmed and 33 lakhs the demand has been dropped because it was not disbursed. My lord, am I clear, my lord?
9 crore 53 lakh.
It was disbursed.
It was disbursed to you. They want recovery now.
Recovery.
And this 33 lakh, since they have appropriated,
So they say
so
that
dropped.
proceeding dropped.
Dropped.
Now similar is the case, my lord, in the third page, my lord. 7 crore something. Demand dropped. Disbursement denied. Money retained with the revenue. So this amount was not disbursed. So they say that since it has not been disbursed,
proceeding dropped, and the amount is with the department. Similarly, my lord, 68 lakh something, my lord, demand confirmed, petitioner direct to pay with the interest.
So if you go by this chart,
My lord,
first one,
my lord,
5 crore 71 lakh 89,425,
My
they
lord.
have retained.
my lord,
Next one,
953, 41, 215, demand confirmed, and 33, 18, 552
that
dropped.
was that drop was they have retained.
My lord, 33 lakhs
They have retained already.
retained.
9 crore 53 lakh
Disbursed,
disbursed.
so recovery notice.
Notice. So okay.
The third one, 7 crore 72 lakhs, something, demand dropped, disbursement denied, money retained. And the
Yes.
fourth one, 68 lakh something, demand confirmed, petitioner directed to pay.
So out of these figures,
My lord.
9 crore 53 lakh 41,215.
My lord,
That amount was only disbursed.
that was disbursed.
Others are not.
No, my lord, you also may see that this 33,000 lakh something was also paid. In the second column, my lord,
Second column, both are paid.
both are paid. And the third column also, my lord, 68 lakh something paid.
No, fourth.
Fourth, my lord,
Okay, this is also disbursed.
paid.
They want it back, those amount back.
My lord.
And
The amount which has not been disbursed, less-
5 crore 70, 1 lakh
my lord,
89,000,
33 lakhs and 7 crore 70.
33 lakh disbursed, I think.
No, they dropped, my lord. You lost me see third column, my lord.
Hmm.
You lost me see the fourth column, just demand confirmed on so and so. Prior to that, 953, 41, 215. Confirmed.
No, one by one, let us see.
My lord, my lord, my lord.
5 crore 71 lakh 89,425.
Not disbursed,
Not disbursed.
my lord,
Next figure.
my lord.
9 crore 53 lakh 41,215.
Disbursed. Recovery,
Just disbursed or not disbursed?
disbursed.
Ah.
Recovery,
Then next is 33 lakh 18,552.
that is not disbursed
Not disbursed.
and proceeding dropped.
7 crore 72 lakh 73,741.
My lord, not disbursed,
Not disbursed.
proceeding dropped.
68 lakh 83,000.
Disbursed and recovery to be made. So my case, my
So
lord,
you want retention of the money already paid,
my lord,
right? And release of the money which they have retained,
retained and
plus interest.
interest on the basis of the refund orders which have
That I have understood.
attained finality. My lord, in fact, the facts are all these things, but this is the crux of the matter, which is I am trying to argue for Lordship. And I was trying to submit before Lordship, you know, that the first part where the recovery is sought to be made is duly covered by the judgment of the apex court, that cannot be done. The second part also is covered by the judgment of the Supreme Court also, where they say the matters which have attained finality cannot be disturbed. Plus the division bench judgment of this honorable court, where also the refund orders were passed and no appeal was filed. And the only single judge directed that the refund should be made. That was not under challenge, and the court upheld the judgment. And the grounds, my lord, I have summarized
Yes.
in the bottom, my lord, grounds. Mainly my grounds are there, my lord, which I have summarized. One, that the order of the 11A is prima facie contrary to Supreme Court judgment and the High Court judgments because, and against the judicial discipline, because in spite of taking notice of the Topsum and Kesri judgments and the circular of the board, whereby they have decided not to file an SLP.
What I have noticed from the date of the refund orders,
My lord,
that all the refund orders were passed after SRD and before,
unicorn.
what more is required?
No, my lord. What I said,
Ah.
that the Topsum and Kesri judgment was taken note of in the 11A order. The authority also takes note of the fact that the board has decided not to file an appeal.
So there is a set of words in section 11A,
My lord,
which is erroneous refund or recovery.
refunded or my lord, not
What
paid.
is the word?
Refund.
Ah.
Refunded. My lord. Victor can दिया सुन.
Erroneously refunded.
My lord.
That was not the case on the date of the refund order.
Exactly, my lord. What I am saying, trying to say.
What
my lord.
is erroneous? Now they have interpreted
My lord.
after while issuing all these recovery notices.
My lord.
That was not erroneous on the date of the refund orders.
Absolutely, my lord. What I was, I'm really highly obliged, my lord. In fact, what I was trying to submit for lordship, my lord, that is.
Decided by our High Court.
No, by going by the statutory provision, what is erroneous? Erroneously refunded. Refund orders were passed on the basis of the judgment holding the field as on that date. It was not refund, erroneous. It was exactly in conformity with the principle laid down in SRD.
Case किमान है?
Subsequent judgment cannot, you cannot go back to that position. No. Yes,
Lordship में
judgment,
My lord, I'm
the
sorry.
principles laid down is, in the judgment is always retrospective, but question of reopening the case is different.
Lordship में kindly see at page 14 of my compilation, my lord.
Victor can.
Victor can.
Hmm.
Para 7, my lord.
Yes.
The point urged by the learned counsel for the appellant is that under section 31 of the Assam Sales Tax Act, the power of revision by the Commissioner of Taxes can only be invoked if the commissioner is of the opinion that the orders of assessing authority is erroneous and prejudicial to the interest of revenue. In the present case, the order of assessment was in conformity with law on the day when the assistant commissioner passed the order on so and so. The order of assistant commissioner was rather against the dictum of the pine chemicals and so, which judgment was rendered on 16th January 1992. What is to be seen is that what is the law prevalent on the day when the assessment order was passed. Even if subsequently the law is changed or reversed, the assessment already completed cannot be allowed to be reopened. Reference was made so and so.
That is what I said
My
just
lord,
now.
my lord, exactly, my lord, exactly. I may read one more paragraph, my lord. Therefore, the question to be answered was the order erroneous when the order of assessment was passed? The answer has to be in negative. In as much as when the order was passed, even the order of assistant committee of taxes was passed on so and so, the law laid down by this honorable court and includes so and so was that the exemption of the payment of taxes is generally and no sales tax were payable on industry like the parent for the case of period so and so. Thereafter, the judgment was, my lord,
were there. Various judgment of the very different high courts were produced, my lord. The lordship may see 9, my lord. The matter can be looked at from another angle. This court in Mahavikok Industry versus so-and-so, a division bench, which judgment was pronounced on so-and-so relying on the earlier judgment of this court, as well as the Pine Chemicals Limited,
Fine chemical reverse.
my lord, took the view that the industry, like the appellant, were entitled exemption from payment of central sales tax of the so-and-so. Against the aforesaid judgment, SLP of the revenue was dismissed on so-and-so. Thereafter, the revenue filed a review petition before the apex court on the ground that the judgment reported in so-and-so already stood reviewed and reversed in the case of the so-and-so, and therefore the order passed in the SLP dated so-and-so may be reviewed. However, the apex court dismissed the review petition on so-and-so. From this, the learned counsel emphasized that the law as it exists on the date of the passing of the order has to be seen, and the judgment reported in so-and-so would be applicable in respect of the assessment which are made after the date of judgment according to so-and-so prospectively. So here also a lawsuit will find that after the judgment of this honorable court, the matter went to Supreme Court. The SRD judgment review was dismissed. Then the matter again came up before Saraswati Milord in the Saraswati matter. And there also the law was reiterated that no, in respect of the matter which have attained finality, you cannot reopen. The judgment of the subsequent judgment of Unicorn will apply in respect of the pending proceedings, but not in respect of the matters which have attained finality. So this judgment supports my contention, my lord, that 11A cannot be invoked at all because that deals with erroneous refund. And in this case, whatever refund was granted were not erroneous, but were in terms of the judgment of the apex court in assault articles. So, my lord, the learned single judge also, my lord, proceeded on that basis that it is not erroneous. The appeal was dismissed, and board decided not to file an appeal SLP against the said judgment. They waited finally. So, in my humble submission, my lord, to make further, my lord, submissions before lordship will be to take, my lord, precious time of your lordship, my lord. If necessary, after my London friend make the submission, I may give a reply, my lord.
Yes. May I please, Lordship, in my humble submission, the point for determination before Lordship is a very in narrow campus. Whether after Unicorn, if the proceeding is not finalized, whether they are entitled to refund on. This is the, in my humble submission, this is the point. Lordship, in first writ petition, Lordship, please to see page 1, writ petition number 1468.
Yes, Mr. Dotto, you are waiting for what? There is an item, next item 5. Not possible. Let it come some other time. Maybe.
Lordship, page 98 of the writ petition 1498, 1468.
The judgments which I 4 line summary I may provide to you so that it becomes some judgments which I refer. I'll give 4 line on your judgment reference.
Yes.
On the issue.
Mr. Kyle, where to go?
Lordship, page 98.
Okay, Mr. Kanodia's petition.
Yes, Lord. Order in original. Lord. Order dated 11/2/2020.
Just a minute. Page number?
Page, it's order start from page 95.
Order starts from page 95.
95. Order dated 11/2/2025.
This is, okay, order.
Which has been put under challenge before this honorable court.
Dated 11/2/2025. Yes.
Lordship may skip some paragraph. Lordship may come to page 98. Discussion and findings.
Yes.
Lordship may come to paragraph 16. May I read, Lord?
Hmm.
Paragraph 16.1. I find that the earlier so-called notice dated 16/4/2010 by the Assistant Commissioner was issued to the SSC by rejecting the self-credit for period from April 2010 to May 2010 due to non-eligibility of exempted benefit of central excise duty in term of notification 20/2007 dated 25/4/2007. In order to protect the government revenue, the department further issued another 22 numbers of judicial so-called notice to the SSC for the period from 2010 to 2016. Next, I find that all the charges as specified in above 23 notice SCNs have been dropped by the commissioners, Central Excise and CX Dibrugarh Commissioner by order in original dated 29/1/2025. From the financial year 2010-11 onward pursuant to the Honorable Gauhati High Court's order dated 25/10/2024. It is pertinent to mention here that by order in original dated 21/4/2010, the Assistant Commissioner Central Excise Dibrugarh Division, Dibrugarh has passed eligibility order to avail the benefit of exempted in notification number 20/2007 dated 25/4/2007, which is also upheld by the Honorable CSET Calcutta by final order dated so and so, and the Honorable Gauhati High Court by order dated 25/10/2024, which is accepted by the competent authority as specified in original order in original dated 29/1/2025. Then paragraph 20. On the basis of submitted document and the record available with the office, I find that the SSC has taken self-credit during the material period from the financial year 2009-10 to 2014-15. As such, I proceed to re-examine the amount refunded to the SSC for the period from 2009 to 2015 on the basis of submitted documents, available record so and so, dated so and so by the Commissioner so and so. Then table is given. Then Lordship may come to page 104, paragraph 24. The SEC has also claimed refund of education cess and secondary cess of higher education cess, stating that the cess amount is also refundable along with the excise duty amount whichever is applicable. They have submitted a copy of the order dated 10/11/2017 issued by the Honorable Supreme Court of India, wherein it has been declared that the cess is to be levied on calculate on the aggregate of all excise duties. Therefore, it is clearly referred that where there is no excise duty payable, as it is exempted, there would be not any education cess as well. Paragraph 25(1). I have gone through the matters of refund of education cess and secondary cess, higher secondary cess, and I find that the SSC has submitted an order dated 10/11/2017 issued by the Honorable Supreme Court of India, two-judge bench in the matter of SRD nutrients versus Commissioner of Central Excise, Gauhati in civil appeal number so and so. In the said order, appeals of the party was allowed, and it is held that all the appellants were entitled to refund of education cess and higher education cess, which was paid along with the excise duty once the excise duty is exempted by levy. Paragraph 26. However, I find that the Honorable Supreme Court of India, three-judge bench, has also given a judgment on 6/12/2019 in the matter of Unicorn versus Union of India, wherein the following decision is made by the Apex Court. Paragraph 43. Thus, it is clear from the division bench decided SRD Nutrients Private Limited and Bajaj Auto Limited, the previous binding decision of the three judges bench in Moti Rubber Supra and Rita Textile Private Limited were not placed for consideration. Thus, the decision in SRD Nutrients Private Limited and Bajaj Auto Limited are clearly per inquiry. The decision in Moti Rubber Supra and Rita Textile Private Limited are binding on us being the coordinate bench, and we are specifying the follow them. We do not find any ground to take a different view. 44. Resultantly, we have no hesitation in dismissing the appeal. The judgment and order of the High Court are appealed, and the appeals are dismissed, no costs. Then paragraph 27. While passing the above order, the apex court observed the following. Paragraph 40. Notification dated 9/9/2003 issued by the present case makes it clear that the exemption was granted under Section 5A of the Act of 1944 concerning additional duty under the Act of 1957 and additional duty of excise under the Act of 1978. It was questioned on the ground that it is provided for the limited exemption only under the Act referred to therein. There is no reference to the Finance Act 2001 by which the NCCD was imposed, and the Finance Act of 2004 and 2007 were also not invoked. The notification was questioned on the ground that it is shall have the included other duties also. The notification could not have contemplated the inclusion of education cess and secondary and higher education cess imposing by the Finance Act 2004 and 2007 in the nature of the duty of excise. The duty of NCCD education cess and secondary and higher secondary cess are the nature of additional duty, and it would not mean that the exemption notification dated 9/9/2003 covers them particularly when there is no reference to the notification issued under Finance Act 2001. There was no question of granting exemption related to cess marks, not in vague at the relevant time imposed later on by Section 91 of the Act of 2004 and Section 125 of the Act of 2007. The provisions of Act of 1994 and the rules made thereunder shall be applicable to refund, and the exemption is only reference to the source of power exempted the NCCD, the education cess and the higher education cess. A notification has to be issued for providing exemption under the said source of power. In the absence of notification containing an exemption to such additional duty in the nature of education cess and secondary education cess and higher education cess, they cannot be said to have been exempted. The High Court was right in relying upon the decision of three-judge bench of this court in Moti Rubber Limited Supra, which has been followed by another three-judge bench of this court in Rita Textile Private Limited Supra. 41. The circular of 2004 issued based on interpretation of the provision made by one of the customs officer is no avail, and as such the circular has no force of law and cannot be said to be binding on the court. Similarly, the circular issued by the Central Board of Excise and Custom in 2011 is of no avail, and it relates to the service tax and has no force of law and cannot said to be binding concerning the interpretation of the provision by the court. The reason explained in SRD Nutrients Private Limited Supra that there was nil excise duty. As such, the additional duty cannot be charged. It is also equally unacceptable as additional duty can always be determined and merely granted in respect of the particular excise duty cannot come in the way of determining the yet another duty based thereupon. The proposition adds that simply because one kind of duty is exempted, the other kind of duties automatically fails cannot be accepted as there is no difficulty in making the computation of additional duty which are payable under NCCD, education cess and secondary and higher education cess. Moreover, statutory notification must cover specifically that the duty exempted when a particular kind of duty is exempted, other duties, other type of duties or cess imposed by the different legislation for the different purpose cannot be said to be have been exempted. Then paragraph 28, from the above, I find that the refund of excise education cess and higher education cess cannot be made, and accordingly the same demand is to sanction in accordance with the above stated judgment of the Honorable Apex Court. Paragraph 20, the SSC also claimed the interest based on the fixed special rate of value addition.
Interest is granted on the
Basic excise.
refunded amount, basic
Excise
excise
or interest?
duty, refund of basic excise duty. So interest is not the dispute.
Yes,
If that is what he is contending is that refund of education
Yes,
cess
cess
and refund of higher education
Yes,
cess plus interest. Right?
Lordships, plus interest.
So he is saying that his right has been crystallized. Just 1 minute. This refund order in your case includes all education cess amount and higher education cess. No doubt about it.
No, sir. Only
No, basic plus education cess,
only education cess and higher education cess.
this refund orders.
Right.
Those are there.
Right.
Plus refund of basic,
There's no dispute about that.
no, that the components, in the refund orders, there will be three components. One is refund of basic excise duty. Second is refund of education cess. And third is refund of higher education cess. Your refund orders contained all the three components.
Only two components, because excise duty was earlier passed, which we have not passed.
Or these are separate for cess amounts. Your refund orders are separate for cess amounts after as part of the SRD. Your case. Your case is not refunded.
Not
Education cess.
education.
so his education cess was rejected by the authority, Lordship, on the ground stated by in previous paragraph 27 and 28, Lordship. His Lordship, page 107, order. I hereby sanction refund of central excise duty of rupees 2,45,61,860 and interest of rupees so and so, then totaling rupees so and so, only for the year financial year 2009-10 to 2014-15 to Mr. Diro Plus so and so, towards refund of excise duty in light of the special rate fixed so and so by order dated so and so. But he was refused to pay the refund the education cess and higher education cess. Ground stated here. Lordship, now I want to place my affidavit, Lordship.
Your affidavit.
Yours,
In
page
this case.
187. It start from page 186.
Yes.
Paragraph 4. Here it looks. That with regard to the statement made in paragraph 8 of the writ petition, the answering respondent beg to state that the executing authority by order in original dated 21/4/2010 allow the petitioner to avail benefit of exemption item of CBSE notification dated so and so as amended. However, the A held that the petitioner had sufficient amount sentiment credit available to them on the last day of the said month under the consideration, and hence nil refund was sanctioned for the month of November 2009 as per the terms of the condition laid down in the notification 20 of 2007 dated 25/4/2007 as amended. Then paragraph 5. That with regard to the statement made in paragraph 9 of the writ petition, the answering respondent beg to state that the petitioner submitted option for availing self-credit duty for the financial year 2010 and 11 in term of notification numbers 20 of 2007 dated so and so as amended by so and so, which was accepted and communicated to the petitioner by letter dated 22/4/2010. However, the Commissioner of Central Excise and Service Tax Dibrugarh reviewed the order in original and appeal was filed by the before the Commissioner Appeals Gauhati to determine whether the petitioner are eligible for availing exemption under clause 5A of the notification number 20 of 2007 as amended. Then paragraph 7. With regard to the statement made in paragraph 11 of the writ petition, the answering respondent beg to state that a total 23 numbers of so-called notice for the period of April 2010 to January 2016 were issued to the petitioner to protect government revenue.
We have
Eh,
already read
yes.
this. We have already read all this.
No, I'm just what have been stated in my affidavit, Lordship. We are
There is
listening.
nothing new.
Yes, Lordship. That has been submitted. Lordship.
Nothing new. He has quoted from Unicorn and all. There is
Then-
nothing new.
Paragraph 10.
And this is part of the final order.
Yes, Lordship.
Concluding part of the impugn order.
Yes, Lordship.
That's
That is-
all. He has repeated it.
No,
Reproduced it.
what-
Paragraph 10.
Whatever is stated in my affidavit that has been placed before the Lordship.
No,
So
what is
his claim was not determined, whatever is stated by my learned friend, that his claim has been determined after, before Unicorn judgment is passed by the Honorable Supreme Court. This is why I want to place before the Lordship. Then paragraph 13 may kindly be seen, Lordship. Paragraph 13,
Same
page
thing.
193.
13 is same. These are facts.
No, Lordship, page 144. Hence the refund of page
Page?
194.
Huh.
Top, Lordship. Hence the refund self-credit of education cess and secondary cess of hiring was never sanctioned to the petitioner at any point of time in terms of notification number 20 of 2007 as amended with read with Honorable Supreme Court three-bench judgment, judges bench judgment dated 6/12/2019, that is Unicorn judgment. So it was never sanctioned, Lordship. It was never concluded that education is to be refunded to them before Unicorn judgment was passed on the basis of SRD laws. So the contention raised by placed before a Lordship that his demand for education was determined by the department before Unicorn judgment was passed. That is not correct, Lordship.
You want to make any replies?
This factual part has been submitted by my learned secretary. So those letters and everything is.
In that letter, Lordship, we have not stated.
They have not referred to in the impugned order also.
That was placed by my learned friend at the time of hearing, Lordship. Lordship, letter dated 7/12/2019, paragraph 2. It has been found that your eligibility for benefit of the exemption under notification number 20 of 2007, which is a prerequisite for availing the benefit, has been challenged by the department before the Honorable CSET Calcutta. The case is still pending and registered under Central Excise appeal number so and so. Therefore, your claim for refund is hereby returned. Because at the relevant time is appeal before the CSET was pending, so it was returned. There is no mention about education as another thing. It was never confirmed before Unicorn judgment was passed. So Lordship, in my humble submission, consider point for consistency, Lordship, in both the cases, whether their claim has been determined before unicorn judgment, whether they are entitled to any refund of education cess.
Dr. Saraf's case all are
Yes, Lordship, I'll place that.
dated prior to,
No, Lordship, it probably, I have prepared a chart, Lordship.
huh?
I have prepared a chart. Yeah, Lordship, may please compare our chart and my learned friends, seniors, Lordship, whatever is in available on the record, we cannot
Only
change.
the present disputed facts here on
Yes.
the date of the regard. Then we will say that these are disputed facts. You go back to the trial court.
Yes, Lordship.
That you say one refund order, then the other party say no, this refund order is of this date.
My contention before Lordship that nothing was determined before unicorn judgment was passed. That unicorn judgment was passed. This is the chart. Lordship may verify whether my contention is correct.
Let verify, you tell me.
Lordship, in the chart, demand comes some cause notice. So cause notice. First is demand sub cause notice dated 27/11/2003.
You give the year also, then only I can compare.
Page, Lordship,
No, why should always prepare?
No,
They have given in year wise.
Lordship, interestingly, neither both the petitions have not given their compilation to me, Lordship. Probably one has been given just now. Can't be. Probably, Lordship, my senior friend has given me this just.
No, this one only, short one.
Sort is not given, Lordship. Not given.
Page number 5. Refund orders sanctioning the above amounts were passed as follows.
It was not given.
Dates are given, pages are given.
Lordship, that was not provided to me.
No, this written submission. Brief note.
Probably my learned friend in the earlier petition has not given us any
No,
document.
in a second one, Dr.
No, Saraf has given one compilation just now.
Because so far Kanodia's case, I have heard him enough, so I can
Lordship, our contention
understand
in our
his case and your case. But Dr. Saraf's case, I have gone through brief note. Now, these are the highlighted part. Come to paragraph, page 5.
page 5. Okay.
There are 5 bullet points. Have you got
That
it?
is not in my hand, Lordship. One compilation is given by
And,
senior advocate, Lordship.
Brief note is with him.
If not, I can give him without.
Huh.
And then also it was one more copy.
No, Lordship. I'm sorry.
I will have to take this much of that.
This one.
It is not in my hand, Lordship.
So many cases you doing which file is keeping.
So these are separate files. I kept at the very particular Lordship.
You can take one more copy. There's nothing else.
Page number 5.
Lordship.
5 bullet points.
Yes, Lordship.
Leave the reference number. Right. Refund order dated 2/4/2019. Right. 1. Refund order dated 7/6/2019. Then third, refund order dated in bold.
Lordship, it is matching with my.
Matching.
Yes, Lordship.
Matching, then matching.
Yes, Lordship, it is matching.
Mixtures are there.
Pages are also there.
Yes, Lordship, it is matching.
Matching.
Yes, Lordship.
Then okay.
Then Lordship.
Then see the dates now.
Then date is 7/6/2019.
Now,
Yes.
what is the date of unicorn?
It is 2019. This is 2019.
Which of the refund orders are after?
Lordship, whatever.
No,
there
no.
are-
These are yes and no.
Yes, that is correct.
Which of the refund orders are after unicorn?
Lordship, all are before unicorn law.
Unicorn.
Then thereafter we preferred review application.
Review.
Yes, Lord.
Before Supreme Court, SRD.
SRD.
That before the department, Lord.
Huh?
Department, before the department. Lordship, page 338, 405 and 422.
What happened to those?
Lordship. I'm placing
330.
338.
It will divorce. ইটো কি নাম আছিল ইটো কেছৰ হিন্দুস্তান ইউনিলিভাৰ What is the sum and substance of the review order?
Review order, Lordship, page 391 of the
Review is for what?
review by the department, Lordship.
Review by the department. To
Lordship.
file appeal.
Yes, Lordship.
To file appeal.
Yes, Lordship.
Okay, to file appeal.
Lordship. Page 391 is the, I therefore in exercise of power conferred upon me under section 2, subsection 2 of section 35B of the Centralized Size Act,
Repeat.
direct the Assistant Commissioner to apply for the Commissioner appeals.
338.
338. It start from 338, 388, sir.
Huh?
388.
388. Huh.
Then operative part is at page 391.
Hmm. Then
Then appeal was preferred, that is at page 483.
four
483.
483. It starts from which page?
Let's say that order that has been quoted in this order.
Huh?
That is annexed page 467. Annexure double H.
This is part of what?
It is a part of order dated 11/3/2023. Page 467.
Original.
Yes.
Original 23 cannot super 23.
No, I am just placing that appeal in order. Paragraph 2, page 482. What will be clarified from paragraph 2, page 482.
Yes.
I find that the competent authority similarly found refund order dated 7/6/2019 by order in review as not proper and not tenable in the eye of law, as it failed to comply with the Honorable Gauhati High Court's stay order, which was operational till the date of next hearing. In all the three refund order dated so and so, appeals were filed by the Commissioner Appeals by appeal number so and so. Then paragraph 3, I find that the Commissioner Appeals Gauhati by order in origin appeal number so and so stated that paragraph 8, in view of the above decision of the Honorable Supreme Court of India in the above cited case, it became clear that the notification that gave benefit of exemption from the central excise duty to the industries operating in northeast part of the India does not exempt automatically education cess and higher education cess. Hence, the sanction of refund of education cess and secondary and higher education cess by the lower executing authority is devoid of any legal authority, and as such merits to be set aside. Further, the decision of the lower authority for appropriating the amount of refund erroneously, so sanction is not legally tenable, as the said erroneous refund is no longer available for appropriation towards any duty that may be pending for recovery against the SSC in the record of the department. If a refund amount is once found to be not valid and erroneous, then the consequent application of such refund amounts to any other purpose is also became invalid. Therefore, the original liability against the SEC is to be restored by the department as the refund amount sanctioned and appropriated by the lower authority is no longer sustainable in the light of the Honorable Supreme Court judgment cited above. Further, it is to be observed that since the main question of legality of sanctioning of the refund has been examined and a decision has been arrived at and two questions framed by the department in appeal stands answered and they do not merit any further discussion. Notwithstanding anything, notwithstanding the above finding on merit, I find that it is on record that the impugn order was passed by the lower authority without the knowledge as to stay order of the Honorable High Court of the Guwahati being still in force. The appellant has stated in the ground of appeal that the impugn order passed by the executing authority is not legal and proper, and the same was passed without taking into organize of the stay order of the Honorable High Court of Guwahati, and the matter was sub judice. On perusal of the fact on record, I find that as rightly submitted by the appellant, the subject issued is sub judice and on being bounced by the principle of judicial discipline, all that insofar as the impugn order is passed while the stay of the Honorable Guwahati High Court of the Guwahati is operational to the extent the order is devoid of any legal authority and needs to be set aside. However, I hold that the Honorable Supreme Court of India, the Supreme Court judgment in the case of Unicorn Limited has titled the balance of convenience in favor of the revenue and has material and legal implication to the cases pending before the High Court, Honorable High Court. The above judgment needs to be authenticate and the consideration of the Honorable Guwahati High Court for the necessary reliance of the department to safeguard the interest of the revenue. I find that the identical issue, the department has filed 2 more appeals bearing number so and so passed by the Assistant Commissioner Central Excise Division Tinsukia. Since the issue involved in these appeals are same, I hold that the finding and ratio pronounced in the order also holds good and squarely applicable for those 2 appeals. Consequently, all these appeals stand disposed of in terms of the above terms.
Now, what is the page 388? What is the ground for review,
Lordship,
Mr. Kal?
Lordship. Married Lordship, page
What is this?
388. Subject review of refund order dated so and so passed by the Assistant Commissioner Central Excise and Central Excise Tinsukia Division in the matter of Hindustan Unilever Limited Personal Product Factory in Unit number 2, Dumduma, Guwahati. In exercise of the power conferred upon me under subsection 2 of section 35E, the Central Excise Act 1994, I, Ravindra so Commissioner so of Central Excise, have examined the refund order number so passed by the Assistant Commissioner Central Excise Tinsukia Division, herein referred to as the executing authority in the matter of so. Then statement of facts. Then paragraph 3, page 390. On careful examination of the scrutiny of the MP.
Come to 389.
389.
Mm.
Paragraph, let's say 2.2.
Mm.
In terms of the Honorable Supreme Court judgment dated 10/11/2017 in civil appeal number so and so, the SCCA submitted a refund application making refund of rupees so and so as education cess and higher education cess period for January 2012 to February 2015, which was paid along with the excise duty and no refund was sanctioned for the education cess and secondary education cess along with excise duty demanded. The educating authority on necessary verification of the refund claim observed that the SSC was eligible for refund of rupees so and so in terms of Honorable Supreme Court's order dated 10/11/2007. However, the executive authority also observed that the SSC had availed rupees of 10 crore 76 lakhs 42,091 to excess of their eligible amount of 50% as per the order of the Honorable Gauhati High Court dated 7/3/2018 in WPC number so and so, and observed that the SSC had not reversed the excess amount availed as self credit. Accordingly, the executing authority sanctioned an amount of rupees so and so as refund of education cess and secondary education cess for the period from 2012 to February 2015, an order for appropriation of the same against their pending dues, and thereby refrain from disbursing the amount as refunded to them.
What is this 50%? In
Proxy-
excess of their eligible amount of
While the appeal
50%?
was pending before the Honorable Supreme Court.
But no, what is this?
Lordship,
What
It
is these details? The adjudicating authority also observed that the SSC had availed rupees 10 crore something in excess of their eligible amount of 50% as per the order of the Gauhati High Court. Or what are all these?
Lordship, what happened, Lordship, while the appeal was pending before the Honorable Supreme Court, some contempt petition was filed.
Appeal was, which appeal was pending?
That regarding 50% to be under BPA.
What is this Gauhati High Court order?
Lordship, probably that is not in, probably that is in case of BBF, Lordship.
Hmm?
That judgment was passed by this Honorable Court. Lordship, while the appeal was pending before the Honorable Supreme Court, the different contempt petition has been filed. Then the department moved the Honorable Supreme Court. Then Supreme Court passed an order, interim order on 7/12/2015.
This order in review was passed when?
It was passed on 2/9/2019 before SRD. Lordship.
No, after SRD.
Yeah, after SRD. Before Unicorn.
Then what has been decided? To apply for appeal.
Appeal, Lordship.
Then appeal order,
Appeal order is not annexed, Lordship.
when the appeal was filed. We appeal.
Appeal was filed on 26/2/2020. Order in
Come to
appeal
449.
26/2/2020. But that
Come
order
to
was
449. I have just picked up one.
4/9.
Four four nine.
4/9, Lordship, is a letter.
Letter, appeal filed by
Appeal
Deputy
filed by the
Commissioner.
Deputy Commissioner. Sinsuke so on 18/6/2019 passed by the Assistant Commissioner, passed by the Commissioner. Kindly refer to the appeal. Appeal is
So this was on 23rd September.
Lordship. 27 September 2019.
All are mentioned in the brief note. All these are mentioned in the brief note.
Probably this is not mentioned.
And there is an appellate order also.
I will just check up because today you will
Not
just,
today,
I will go through it,
just-
Milord, and
huh.
press everything, Milord. like
Because something, if they, because in both the cases, in his case, the department was pursuing. Then in your case also, refund order is there by the original authority. There may be a review order thereafter followed by appeal. In such situation, it may not be, say the issue is dead. right? They may go for, they have the right to appeal, the statutory right to after a review order by so-and-so, to prefer an appeal against the order,
Absolutely, my lord, they know.
right? So, if I miss those again, it will be,
No, my lord, I will, my lord, not at all, my lord, whatever. facts are
because
there.
on the first day of one of the order, I have just picked up and flipped through the
Lord,
pages, then it's,
Well, I will
it is
argue,
no,
I will argue by
no, no.
placing all the facts,
right.
not suppress
No,
anything.
no,
from
no,
the lord.
no. It is not that. I find that one of the appeal filed in September 2019.
September 2019 appeal,
Yes, yes.
appeal is 2020, February.
No, no, no. This page 449,
449,
pi-
sir.
I could pick up. I have picked up,
Yes, Lordship.
not by Mr. Kayal.
Lordship.
I think
I was flipping through, and this I have seen whether this is correct or not. I don't know.
Yes, Lordship. That can be verified from the record, my
no,
lord.
that everything will be on record, my lord. There is nothing.
Oh, no, it is on record. That is why I am asking.
My lord, absolutely correct, my lord, absolutely correct.
Say for one example, appeal filed by this 18.6, right? 18.6. Order in original,
My lord,
then order in review was dated 2/9/2019,
my lord, my lord.
and appeal registered on 23rd November to September 2019.
My lord.
Meaning that before Unicorn, they were
Yes, Lordship.
in appeal.
My lord.
And just verify the facts.
No, I will, you also
No
may give
issue,
me
we'll
I will-
continue.
on the affidavit, my lord, whatever facts.
Because
are
it
there.
is very difficult for me to go through.
No, no, my lord. I will-
Sudden by accident, because I proceeded on the basis that the refund order, end of the matter. On a basic basis of a brief note. Mr. Kayal was also not submitting. But suddenly I was going
No, no,
to
my lord, I
reach.
will go through the everything, my lord.
But
And-
in my note, Lordship, I have given the dates.
And as the note was prepared for your lordship,
Because he has given something.
my lord, as the note was prepared,
He said order in appeal and also review order. Prior to all the review orders on 2/9/2019. Meaning thereby, that was not dead, it was alive. The
Yes.
refund orders. And thereafter, there was an order in appeal
I
according to
think
him.
review orders are
Yes.
19,
Huh. And
but the orders are.
when it was in the pipeline.
Yes, Lord.
Those sanction orders were passed in June. Well, I'm just
Huh.
submitting, my lord.
Huh.
June.
I don't know whether that limitation.
No. Sanction orders were passed in June 2019. How the review orders can be prior to that? I will check up, my lord.
No, review order is in September.
September. That's why I'm saying, my lord.
No,
September.
your orders are in June and July
September is the review order, my lord, for deciding to file appeal.
to file appeal.
My lord.
File appeal.
My lord.
Order in review. Thereafter, immediately within 10 days, they filed the appeal. Right? And when the appeal was pending, this unicorn get crashed into the scenario.
My lord.
It could be, I don't know, it is from he has given just these dates. I could not understand. Order in review.
My lord.
No, no,
Subject
just
matter,
the,
only
just
thing-
the facts.
Well, that I will come, my lord. The only thing which will needs consideration of your lordship is that when the order was passed, whether it was erroneous. Because the proceedings can be there. Without, after all, 11A or whatever orders are there.
No.
They-
Some proceedings are alive.
I will go through.
Now we cannot ignore those
No,
facts.
no. How your lordship can be, Lord? And I will also not like, my lord, that any facts should go out of the, my lord, the knowledge of a notice. of your
Because
lordship.
I don't know much law, but I go by facts.
No, my lord, I will not miss a single
The
fact.
court will go by because I generally follow
Well,
Justice Duliar Road. One must be sure of the facts to understand the law.
My lord, I will, if some papers are not necessary, I
Because-
will ask my colleague to print from the client, my lord, whatever are there, place everything.
Then thereafter it
In
is.
the first matter, there is no such appeal or that is attained.
Now your case is
Pleadings complete.
facts are clear for me
Lord.
because he has suddenly given this what is the review
Yes, Lord.
orders and all order in appeal. That is why I am
Yes,
And
making
the
it.
dates were collected from the pleadings of the my learned friend only. We have filed very short affidavit.
Mr.
So-
Jaini, do you be better?
I'll-
If
I'll
you throw
give-
this kind of, how can I?
No, no, actually it was prepared for our purpose, Lord, sir, not for the purpose
Well,
of
at
the
least
court.
my learned friend is saying that whatever he has given, it is on our on pleadings.
Yes, yes.
So
Lord, sir.
that means, my lord, we have,
No, we are not saying that.
no, I'm saying about my learned friend. So at least everything is there, but
He has quoted from your page only,
So-
from
so-
your brief only.
my only thing is that the facts are not so clear. from
Just after this refund orders, what they were doing,
I just will not go through it and everything prepared, my lord.
just add an addendum to
My
the
lord, my
brief note.
You know, on the basis of no position, I prepare a separate one, my lord. With a reply on the side of the
Yes.
second column.
So far, Mr. Kande, your case is.
I'll just give the list of dates and that 25 application, the letter which I wrote to the department for post the division bench order. That your lordship want to say?
23rd January,
Lordship, so that letter
2020.
and a fresh list of dates, I'll hand over to the learned court.
That's it. That's it.
Lordship, I may be also be allowed to submit written submission in both the cases.
Okay.
Lordship.
When we are next week? Next week, yes.
At the earliest, my lord,
Earliest will be 3rd.
because it's still.
3rd September.
Well, so that matter is
3rd
fresh.
September.
My lord, the fresh in your lordship, mine will
Lordship,
also.
I may appear virtually on that day. Because nothing to argue.
3rd
from my-
September?
My lord, my lord.
Not
Oh, yes, mother.
Number के बाद।
Okay, 3rd September.
Well, item 15, there is an interim order. So, my lord, lordship will fix up a date and we continue the interim order. my lord.
Yes. Just a minute.
That is also an interesting matter, my lord, on
All of it.
interesting matter.
Mr. Kanodia. A. Kanodia. Learned counsel appearing for a petitioner in 2. Has made his submissions. Custodian response. Complete or?
I'll submit my written submission, Lord.
Miss,
No written submission arguments have not been completed.
all,
तो आपका clear, हाँ?
Mr.
क्या क्या बोलते हैं?
Sorry, Miss, and Mr. Esikal and Senior Counsel and Special Counsel CBS
No, no.
for the respondents have completed their submissions in item 2.
Load the-
As the submissions of the Dr. A. Saraf, Learned Senior Counsel appearing for the petitioner in 3 and Mr. Esikal, Learned Senior Counsel and Special Counsel CGST for the respondents in 3 are not complete. These the cases again as started on 3rd of September. Okay, 3rd of September. You file your this
Lordship,
thing
list of dates I will. And that letter.
as part of, huh?
Well, item 15 below your lordship.
15 years or so.
This is also a very interesting issue on the promissory estoppel. So,
Okay.
Lord, if you are also can fix up a date so that
It will be somewhere after 15 September. Yeah, I'll not be available. I'll not be available.
I know 2 weeks your lordship, I think is going.
You were there?
No,
Oh, no, state. Okay.
59 more.
Dr. A. Saraf, stated by Mr. Associate Learned Counsel for the petition. Okay. I sought for listing of the case on another date. Release the case. Anybody state counsel is there? Okay. Release the case on so and so. The interim order passed earlier shall continue till the
Well,
next
item
date.
3 also there is interim order, so that may
Okay,
continue.
interim orders wherever passed earlier shall continue till the next day semester. Or regarding recovery.
Recovery, my lord. The
Achha.